Welcome to Looking at Legal Stuff. Today we have 19 hearings, including 3 family law and 16 minor guardianship ones. There are 3 separate minor guardianship cases filed in addition to the family law case, all 4 of which include the same mom and her daughter. First emergency minor guardianship is filed by mom's biofather and his wife, who say they filed it because the children were left with them after both parents were sentenced to time in jail. Mom quickly decides she doesn't want her father to have her child, and she has her mother and her husband file a second minor guardianship case. But this time it's for a full guardianship, and Mom has consented. But the first set of grandparents decide to fight it out. The third minor guardianship is filed by the child's bio-dad 5 months after the original guardianship battle between the 2 sets of grandparents happened. He's been in jail and unable to participate until now. How will the judges handle these tangled-up cases? Let's find out.
And just for brief history, this matter was before the court on my client's motion to modify the residential schedule. And that was before Your Honor in January. We filed it in January, and I think we were before the court roughly 2 weeks ago for entry, and the court did enter an interim parenting plan that provided my client 6 hours of visitation and appointed Ms. Turnbull as the guardian ad litem. We were before the court on presentation. I think it was last Friday or 2 Fridays ago, and I wanted to provide an update to the court. I did appear on the guardianship docket, and Commissioner Nelson set the matter over to the 21st to get an update at what's happening at the hearing. As I indicated, CPS, Ms. Fowler did appear, and I don't know if she's still present, but she did send me a message indicating that it's still CPS's position that they have safety concerns with mother's home. So they're unwilling to recommend the child to be returned to mother. So we're kind of in this position where we do have a recent entry of a court order. However, I kind of wanted to get direction from the court on how you'd like to proceed, either by a sua sponte motion to provide custody to my client based on our underlying motion, or if I had authority to bring a motion for immediate restraining order, just so that we can have the situation where my client at least has immediate custody given the concerns between the 2 parents, and so that the guardianship can hopefully be dismissed as it's under a 60-day petition.
And guardianship was filed by her biological father, is that correct? Okay. Ms. Turnbull, do you have any information in this case?
Not yet. I have sent paperwork to Mr. Mendoza and have not received it back. And I have not, I've called and texted Ms. Aldrich numerous times and have not received any response. So I don't have a lot of information yet.
And so given the court's recent order, I felt uncomfortable bringing an immediate restraining order just because I understand the court's position, but given the kind of recent developments of CPS's position, as well as mother testified at this court at the original hearing that she wasn't going to be incarcerated. I think the next day she ultimately was incarcerated. I also filed the police reports with the court last week referencing why CPS became involved, because this young child couldn't wake up his mother and was taking care of his 1-year-old sibling, and that's why CPS has recently been involved, and that's why there's safety concerns. So I'm happy to bring a motion for immediate restraining order. Again, I just needed authorization from the court, or if the court's willing, based on our underlying motion, to do so now, I would ask that.
I don't know that I'm in a position to say that you can't do that. This is clearly a unique situation. I just was looking for do you know when the last finalized parenting plan was?
There actually was never a finalized parenting plan. I'll pull up right now, but it's called a residential schedule, and it was from 2017. The person that prepared that just did it under the wrong form, but that's the temporary parenting plan. It doesn't provide any RCW 191s for either parent. It frankly doesn't even address decision making. I don't even know how that happened. And then it provides my client a step-up schedule contingent on an investigation with the guardian ad litem. The guardian ad litem was appointed in 2017, however, didn't complete an investigation. Ms. Kalman, I think around that time, moved out of the state. So I think it just kind of, absent attorneys being on either case, just kind of sat stale with no movement. So procedurally, it's a strange situation. So.
And I'm sorry, when did you say Commissioner Nelson set the guardianship to?
21st.
So just next week?
I informed them that we would be before the court today, and I'd be getting direction on if I needed to file an immediate restraining order or
not. I've not come across this situation, and frankly, I'm not entirely sure how to proceed or to have you proceed, but that's that may be the most direct route. So if that's what you feel you need to do, I'm not going to stop you from doing that. It's clearly grandfather is likely doing what he believes is in the best interest given the circumstances, but that does drastically affect your client, and that's he is entitled as biological dad to have rights to this child. So
would the court like me to present the immediate restraining order directly to your honor, since you've obviously been aware of it, and I can present you new information, or do you have just the normal ex parte procedure?
If you want to do it through ex parte and just put a note on it for me, then I'll look for it.
Okay, I appreciate it.
All right, thank you. And then Ms. Gilmore, if you can just remind your client that he needs to respond to the GAL and get that process started as well. All right, thank you.
And it looks like we're still on for just a procedurally while we're before the court. It looks like we're on for a subsequent review in two weeks for the 28th. Do you want to keep that date, Ms. Turnbull? Do you think you're going to really get anything completed by then, or?
I think I probably need more time, given I haven't heard anything yet.
Okay.
All right. How about we strike the 28th? It looks like it was on for visitation and GAL review. Well, one of those we're still working on. Well, both of them we're still working on at this point. So I'll strike the 28th and it can just be noted back up.
Yes.
I'm here.
All right, Ms. Gilmore is here, Ms. Farr is here. Who is the gentleman who just said that you're here? Can you give me your name?
My name is Brian Fletcher.
Okay.
And I'm Tracy Hedrick. I'm on the line with him.
We're the temporary guardians.
Right. Okay. I know Ms. Gilmore represents the father. Has the mother in this case been served yet?
Yeah.
I don't believe either parent has technically been personally served. At this point, I'm obviously willing to accept service. I don't know if Lillian is requiring personal service, but I don't think either one of the parties have frankly been served. I think if the court wants to go into this, I think that we also have kind of a procedural issue, as my client isn't the biological father of the younger child, Serenity. So that bio parent needs to be named and served as well.
Do we know the biological father for Serenity?
So, Your Honor.
Yes, we do.
Okay.
Here too.
When I spoke with petitioners yesterday, we were not there. My understanding was there was not a birth certificate or a father named for Serenity. But mom is also on the Zoom, so perhaps mom can answer that question.
The person named Lillian, you're the mother of both of these children, right? Are you there?
Can you hear me?
Yes, no, I can.
Can you hear me?
Yes, can you hear me?
Yes.
Do you know who the father is for Serenity Aldrich?
Yes, I do.
What is his name?
Miles Radcliffe.
Miles, and could you spell the last name?
But I actually do not currently know. I believe he's incarcerated. If he's not incarcerated, he's at a treatment center through the courts. have not been in touch with him. He's one or the other right now.
All right.
So I don't know if serving him would be possible or.
All right. Ms. Farr is going to want to contact you to discuss that. She'll do that over the next week or two. And is it Lillian Aldrich? Is that right?
Yes.
All right, Ms. Aldrich, what is your position on the request for the minor guardianship?
I of course wish that they get given back to me. I mean, they've never been away from me. They hardly know the people that they're with now, and granted that they are family. They're not family we've spent a lot of time with. And for both of them to have been taken away completely from all of their entire family, me included, I'm not sure how that's good for the children. I haven't seen my kids since February 28th, and I have not ever been away from them. And I know that I'm really wanting my kids to come home. That's my opinion.
Okay. So I know the father of Maverick is objecting. The mother of both children is objecting. And we need to get, I guess, both the father, McCaven Mendoza, and father Miles, looks like Radcliffe, served.
He would most definitely object.
Say that one more time.
Miles would most definitely object.
Okay, well, he still needs to be served. And that's Ms. Farr, the court visitor, is appointed to help in that process. So she will work with the petitioners on that. I think.
So, Your Honor, if I may kind of just give you a little overview of what's actually going on.
Please.
So there are some, there is CPS involvement, which led to the filing of the petition. And there is also an ongoing family law matter, which I'll let Ms. Gilmore speak to. And she is currently waiting for an order to be signed, giving father custody. I have briefly talked with father, but I haven't actually interviewed him or been able to see the home that Maverick could possibly be living in if father were to get custody. I have not spoke with mother yet, but I will be getting in contact with her this week as well. So I have met with the children. The children are being well taken care of in the petitioner's home. They are, they're safe, they're being fed, they're being sheltered, everything is fine. Maverick is very happy there. And Maverick would like to have some visitation with father. And he has had some visitation with father. And if the custody order is signed by Judge Fassett, then there needs to be some slow integration back into father's care for Maverick's emotional well-being. And so father is on vacation next week, and petitioners are wanting to give father a couple of overnights to see how he does with getting Maverick to and from school, and see how Maverick adjusts to being at father's home for more than one day. And I can't speak as to what's going on with mother because I haven't spoke with mother yet, and I haven't spoke with CPS yet.
And Your Honor, I can update the court regarding the family law matter. We did file a motion for immediate restraining order asking for an immediate transfer of custody into my client's care. I did speak with Bree Broughton this morning, just right before this hearing. She indicated to me that Judge Fassett did sign that immediate order yesterday evening and provided that to the clerks. I just checked Odyssey again and it's still not up. But that is the current, my understanding of what is occurring for the record.
So your position is that order supersedes the order entered in this proceeding?
And that's the difficulty of this case. And that's what I was talking to Judge Fassett about on the record last week. And she kind of directed me to this procedure is doing, at least giving the client, at least on an immediate basis, custody of the child so that this court could allow some sort of transition if that's what they believe is in the best interest of the child. I think procedurally it's difficult because based on the minor guardianship statute, I don't think that the petitioners have really set forth any allegations against my client. And given the fact of, this immediate restraining order, I think that he is willing, he is able. Do I agree that some sort of transitionary schedule might be in the best interest of the child? Frankly, likely, but procedurally, I don't think that we've met the standards for the RCW. And I think that either we order a transitionary schedule back to my client under this case, or frankly, just dismiss for lack of standing.
Well, this court has already entered an immediate emergency minor guardianship. I've extended that pending the investigations, and I think we need to go forward with that. It's interesting when we have competing orders that we have to address.
I've advised my client that he can't obviously just go and pick up the child. There's no sort of intent that we're going to just backdoor this process. if Ms. Farr is recommending, what I was understanding was 3 overnights. What I would recommend is maybe engaging in those overnights, trying to get information from CPS and mother, and then maybe setting another review for a week or two. At that point, the immediate order will be on Odyssey and the court can observe that. I just don't want too much of delay in this process, given my concerns, again, without lack of standing for, any sort of limiting factors to father.
All right, I'd like to, here's my thought. I'd like to be
Your Honor.
Let me finish and then I'll let you speak, Ms. Aldridge.
Could I just say something real quick?
Okay, against what I just said, fine, go ahead. What would you like to say?
I'm sorry, you cut out right there.
Please go forward.
Just that he's my biological father, and we got as children child abuse and neglect and many other things, and I just don't quite understand how my children were put with someone that I was taken away from as a child due to abuse and neglect. And I have always been there for my children. I'm a good mother to my children, and these are allegations. These are not facts. I know I would just really, my kids deserve to be home. And I don't understand how any of this actually came about happening. I asked for help while I was incarcerated, and then this spiraled off from here. My kids have never been taken. My kids have never been questioned. CPS has opened an investigation, but then not continued to follow through because they didn't have anything to stand on. There's nothing legitimately against me as to why I can't have my children. And I just would really like my children to come home.
All right, this petition was filed, and once a petition for minor guardianship is filed, the court has an obligation to follow through. The petitioners have indicated that they will agree to 3 overnights with the father. I'll get to that in a moment. I've also been told that there's CPS involvement. I don't know anything about that other than what I've been told today. What I'd like to do is put this over 1 week in hopes that Ms. Farr can meet with Ms. Aldridge, look at the CPS issues, and I would like to see if we can start the children seeing Ms. Aldridge on some sort of plan beginning next week. And I don't know if that's possible, but I would like to start that as soon as I can. As to the father, if the petitioners are comfortable with the overnights, I'll allow the overnights up to 3 over the next week.
I don't understand how he's allowed overnight visits and I can't even see my children. CPS will again prove the same thing that I've said to you. I've always taken care of my children.
And I'm hoping that that's what we're going to find out in the next week when you meet with Ms. Farr. Okay.
Your Honor, it's been almost a month since I've seen them or talked to them.
Ms. Aldridge, I'm not going to order visitations with you until Ms. Farr has a chance to talk to you.
And I can attempt to call Tracy Fowler again and get an update or work with Ms. Farr on and getting whatever information regarding the CPS investigation as well. I was in pretty constant communication with Ms. Fowler for a while there at the beginning of this case.
All right, we'll see everybody back here on March 28th and at 10:30. And I'm hoping everybody cooperates so we can get an update at that time. Okay.
Is the court entering an order for the 3 overnights, or do you want me to prepare something?
Why don't you prepare something, Ms. Gilmore, on that?
Can I enter that ex parte? I don't have Ms. Aldridge's email.
If you can direct it to me, then I can go ahead and sign off on it.
Okay, I'll do that. Thank you.
All right. All right, next will be the guardianship of Maverick Aldrich and Serenity Aldrich. And Ms. Gilmore is on that case. is, I know McCaven Mendoza is represented. Is Lillian Aldrich here?
Yes, I am.
All right, good. I know Ms. Farr has been investigating this matter, so I think I want to start by hearing from Ms. Farr, and then we'll go from there.
Okay, so Your Honor, there's 2 children in this matter. Serenity is 1 and Maverick is almost 8. Serenity's father is Miles Radcliffe, and he is currently in rehab in Spokane. He has not been served yet. Maverick's father is McCaven Mendoza, who is represented by Ms. Gilmore and is on the Zoom. He has been visiting with Maverick, and he would like Maverick to be placed into his custody. Lillian is the mother of both children. The petitioners are Lillian's biological, well, Mr. Fletcher is Lillian's biological father, and then Tracy is his wife, and they are the couple that has petitioned for guardianship after the children were after there were some issues with mother's drug use and the children's care. CPS became involved. CPS has found that there were no safety issues to leave the children with the petitioners, and that's where they've been for almost 2 months. Father's been having some visits. There's also a simultaneous family law action that between Lillian and McCaven for custody. And there is a guardian ad litem appointed in that matter as well. That's Amy Turnbull. So right now the children are safe where they're at. I don't have any concerns with father at all. I think that, you know, he's married, he has children, he has a full-time job, he has a place to live. He does not have a bed set up yet for Maverick, but the issue is that Maverick hasn't spent much time with him. Between 2018 and 2022, father only had 1 visit with Maverick. So now the visits are ramping up, and I think that my suggestion is that Maverick should stay with petitioners through the end of the school year, which is, you know, just slightly over 2 months, and have increased visits with father. Father has an unusual work schedule. He has 3 days off every week, and then every 3rd week he has a week off. He works 4 12-hour days. And so his days off are different every week. So I think if Maverick can spend those 3 days off with father every week, and then he's spending 3 overnights with father this week, and then each 3rd week add an extra day until we get to the end of the school year. And then by then we'll have more information in the family law action, and then if appropriate, then the transition can take place to father's home, which is what I would anticipate. Mother has some criminal activity that she has to resolve. I believe she has some drug issues that she needs to resolve. She doesn't have a place to stay of her own. She doesn't have a job. I do have a follow-up with mother this week to do a walkthrough at her grandmother's house, who she says that she could stay at if things went that way. And so I haven't talked with the grandmother yet. But she doesn't have a way to provide for the children. And recently her behaviors have been unstable in providing for those children. Along with the drug use. CPS did some drug testing. We don't have that back yet. CPS is going to be closing their case because the children are safe with petitioners right now. So that's basically where we're at.
Are we at a place where we could discuss visitation with the mother, or do we need more information before we can get there?
I think mother's visitation should be supervised at this point until we get those drug tests back and can determine if there's a safe place for mother to visit with the children.
But McCaven has a no contact order against Lily and Maverick. So how would we make that work?
So that is a temporary order that the permanent order hasn't been put in place yet. And that is, there are exceptions to visitation when those orders are put in place.
Okay.
Or there can be, I should say. I don't know that there is right now, but there can be.
Who was speaking just then? So I know.
Tracy.
Okay.
The petitioner.
Okay, thank you.
Mm-hmm.
I'm going to go to Ms. Gilmore next.
Thank you. For the record, Megan Gilmore on behalf of McCabe Mendoza. I think it's important to first talk about kind of procedurally where we are before the court. The court entered an order extending the immediate guardianship on March 9th. That order terminated on March 21st. So as we stand before the court, the petitioners have no legal order allowing them to keep the child. So currently the only order before the court is under the 17-3-00100 cause number of the parenting action, where Judge Fassett on the 21st signs the immediate order transferring custody into my client. I think it's important to note that it's not a no contact order. It's an order, again, providing immediate custody to my client, a do not disturb, do not harm order, not no contact. Under RCW 130225, the moving party must prove that the appointment of the guardian is to prevent a substantial harm and that no other person appears to have authority, ability, or willingness to prevent substantial harm. My client under the current order has authority to have the child in his care. There's an uncontested ability both from the guardian ad litem as well as the petitioners. There's no allegations against my client, and he has a willingness to immediately take care of this child. So I don't think, based on in my understanding of the statute, that a lack of contact would substantiate an immediate order moving forward. And I think that, again, I think it's important to acknowledge, and the court can take judicial notice based on the pleadings in the other case. Any lack of contact wasn't at the hand of my client. He moved forward with having visitation schedule entered in 2017. He was exercising visitation for a substantial period of time. Mother then proceeded to fall off the face of the earth with the children. He could not have any sort of contact with them. He made multiple attempts, and that's in the record of the court. So there's no sort of voluntary abandonment in this case. I also think it's important to acknowledge the fact that the petitioners of this case are, or one of the petitioners of this case is the biological parent. The reason why we mention biological is because his rights were terminated when mother was a minor in this case. So there was a basis for termination, and given that termination, he also had very little contact with this child in this case. So even if this was a best interest of the child standard, which it's not, both my client as well as the moving parties had limited contact. However, my client has reestablished this relationship. The Superior Court, Judge Fassett, found that it was in the best interest of this child to be placed in my client's care based on the standard of that case. And I simply just don't believe that there's a need for guardianship. If the court is going to continue this guardianship, I don't believe that the request has a basis based on the underlying RCW of an emergency guardianship. Emergency guardianship should be short-term. There should be 60 days. There's currently no petition for an ongoing guardianship. So if the proposed schedule to provide transition is adopted, we are going outside of the 60 days. And honestly, even if the court finds good cause to extend beyond the 60 days and we go to 120, we're even going beyond that with the proposal of transitioning over to my client this summer. So based on the court's order that provides my client immediate custody in the parenting action, and simply the lack of, I think, meeting the statutory factors, I don't think that we should continue the guardianship as it pertains to my client and Maverick. I do agree that with Serenity, it needs to continue. However, I think the petition needs to be modified to exclude my client as it relates to that. then the parties would move forward in the parenting action. There is a guardian ad litem. So the child's safety concerns are already protected in this case. My client would be primary parent. Mother will be provided visitation either at today's hearing or a future hearing under that. And the guardian ad litem will provide recommendations to the court on ongoing visitation and recommendations of services. So we do ask the court doesn't extend the guardianship as it pertains to my client. I don't think that there's a basis, and we ask that the child is immediately returned to my client under the Superior Court family law action.
Thank you.
Will your client ensure that the child finishes school where he's currently going?
Absolutely.
All right. The petitioners in this case, Tracy Hedrick, I think you were on the phone.
Yes.
Any response to what Ms. Gilmore is saying?
No, I fully agree. Maverick, we've been facilitating the visiting, and Maverick seems to be loving knowing his dad and going there. Things seem wonderful. We have taken the time to get to know McCaven, his wife, and his other children. We have them up here just because we're concerned grandparents too. And
You're not
they're
grandparents.
wonderful.
So what Ms. Gilmore is saying is that she feels today I should terminate or deny the petition for emergency guardianship as it relates to Maverick, and let Maverick go immediately back with his father. Is that agreeable to you?
Yes, I have talked with Maverick's father last night about this, and we're fully on board with, if it's a bit much, nobody knows how it'll go until we get started. And we're fully here to help McCaven and his wife, if they need some more time or if Maverick isn't adjusting. We're very flexible, but, children belong with their parents, and me and my husband are both on board with that.
Okay. Anybody else want to speak to the issue regarding Maverick?
Can I please, Lillian?
Yes, please.
This is gonna be regarding both of my kids though, but I just want to let it be known that I've been their mother of their children their whole lives. I've been their mother, taking care of them. There has not been any kind of gap with that. They actually have never even helped with that necessarily. I was only incarcerated, unfortunately, and I called them and asked them to take care of my children while I was incarcerated, and they took this and spun this ways as to where we are right now. I'm fully okay with McCaven having Maverick, especially considering he wouldn't be there. But my daughter should not be there either. I don't know how that would work, but I do UAs when I'm asked to. I've done everything CPS asked me to do. There's been no issues. I have done everything that the courts have asked me to do, and I've just been sitting right here hoping that my babies get to come home to me. But I do not believe either one of my children need to be there.
I understand you do not have a place to take care of your daughter.
I do.
Where would that be?
My grandma's house. She's an early childhood education developer, and the only reason I'm not with a home right now is because my boyfriend and I recently broke up, and that put me out, unfortunately, and I was struggling for a short time, and my family is helping me as any family would help anyone in that same situation. And they are very supportive of me having my children, and I agree with Tracy. They should be with their parents, and I truly don't believe or don't, and like I said last time, that there's no grounds for this to be here anymore, and I fully agree with that. But I'm willing to do anything that the courts need me to do. I am a good mother, and I love my children, and both of my children were well taken care of. There has not been any issues in that ever in either of their lives. And for this to happen so quickly and abruptly, it has dramatically affected me. But I've still yet to fall off the face of the earth. But I did when it came to Maverick in that sense, but that was just because things were going different directions. McCaven brought out a new family, and things just didn't happen the way that they should have been. It wasn't an attempted separation between them. It's just things that didn't happen the way that we planned or wanted to. I have no objection to him having a relationship with him. And I don't have continual drug issues. Like I said, the only reason that they had my children was because I called them from booking in jail, unfortunately, and said, please watch my children while I'm in here. They have not been around, nor have they even been willing to listen to me when it comes to any of that. They just assume the worst, and that is why the petition, I'm assuming, was put in. They don't know me, the mother I am. they don't support me, obviously, as they are supporting anything but me. So as you see, the parental support there isn't there, I guess, that they said that they offered. And they have not been grandparents. They just now, when I called them from jail, became that basically. And then since then, I have not had my children back. And it's unfair to me and my children. And I understand that that's probably a lot coming from me, but of course, I didn't mean to be incarcerated. I didn't mean that to happen, but they promised me they would keep my children safe while I was there. And then when I get out, I tried to take my children with me. And then they tried to get me on kidnapping charges on an order I was unaware of. This whole thing needs to be like obviously investigated, which is why we have guardian ad litem set here. But I'm fully capable, fully able, and more than willing to take care of both my children. But I understand Maverick should be with his dad right now through all this, and that's okay. I support that. But I believe my baby should come back to me, especially considering, of course, I want both my children, but as the matter stands, I know he's going with Kevin, but my children, I also want together and I don't want them separated. So I think sorry. Yes.
All right. Thank you, Ms. Aldrich. All right, let me talk about McCaven first. If we're looking at an emergency minor guardianship, that's governed by RCW 11-130-225. And it says that the court may appoint an emergency guardian for the minor if the court finds A, appointment of the emergency guardian is likely to prevent substantial harm to the minor's health, safety, or welfare, and B, no other person appears to have authority, ability, and or willingness to act to prevent substantial harm to the minor's health, safety, or welfare. Ms. Farr has indicated that there should be some phased in visits and is indicating that I'm sure from a what is in the best interest of the child from her perspective. Ms. Gilmore, however, is correct that isn't the standard for an emergency guardian under this statute. And it appears from listening to both the petitioners and Ms. Farr that the father does have, he certainly has the authority to be the parent. That was established by Judge Fassett. He has the ability, he has the willingness, and he does not present any kind of harm to the health, safety, or welfare of Maverick. So based on that, the minor guardianship petition as to Maverick should be dismissed.
Thank you.
And
Mr. That leaves my baby all by herself though, and my baby.
Ms. Aldrich, let me finish here, okay, and then we'll go on to her. Mr. Mendoza will have primary custody. That will be under the family law case. That is going to be heard, I know, this afternoon. I'm going to hear that docket this afternoon. So if it goes forward, then we'll be dealing with, I'm sure, visitation issues with Ms. Aldrich in that case. But for right now, I'm going to dismiss the emergency minor guardianship petition as it relates to Maverick Aldrich. As to Serenity Aldrich, the information is that there continues to be issues with potential drug use, issues with exactly where Serenity would be cared for if she was in the mother's care, as far as doing additional research on that. So at this point, I'm going to extend the immediate emergency minor guardianship regarding Serenity
Your Honor, though these were all allegations that they presumed before the court before having any legitimate proof. And again, my daughter will be by herself and without her brother, without anyone. And my daughter, I don't know how she will be affected by that. And again, like I said, there were accusations. There has not been prolonged issues. And this issue I was incarcerated for was from 2019. Nothing is continual. Nothing is progressive. I take good care of my children, and I do not want them in that home. I'm very thankful that Maverick was put with McCaven. If anything possible, can my child be put possibly with a different family member or anything? My children need to be removed from that home, and that's been what I've been focused on the whole time.
Miss Aldrich, Ms. Farr has indicated that the children are safe right now.
I'm aware,
Yeah.
but they.
Ms.
But
Aldrich,
like she said, the rights were taken from me for child abuse and neglect and plenty of other drug charges as well. I don't understand how they've been placed there so long at this point either.
Because you were on CPS before you got arrested and put our address.
okay, we're not going to talk to each other here. Okay, let me ask Ms. Farr a question. If I set this for April 18th, do you think we'd be in a position to have a hearing on the emergency minor guardianship to make some decisions?
Yes, Your Honor. I have a time set up this Thursday with Lillian to view the proposed residence. And I would think that we'd have drug testing back by then from CPS.
Okay. So I'm going to continue this matter then, at least the Serenity Aldrich guardianship matter, to April 18th. And what I expect to happen on that date is we will have testimony from all parties regarding whether an emergency minor guardianship should be entered for Serenity. And all of the arguments and points that you've made today, Ms. Aldrich, you'll have an opportunity to make all those points on the 18th, and then I'll make a decision on that day. Okay.
Thank you.
All right, so we'll put it over to the 18th. Ms. Gilmore, do we need a formal order on Maverick? Do you want to prepare that and send it to me?
And I think that for the clerk's office, we likely will need, I'll call them and see what they need. So that hopefully they don't have to file a new petition.
Yeah, I think maybe you could just do a regular order. I don't know if there's a one in a form order, but if you just do a regular order dismissing the guardianship relating to Maverick, I think that will work.
When it comes to Maverick,
sorry.
Okay, I will do the immediate minor guardianship order relating to Serenity. Okay.
Am I allowed to possibly contact my son now? I haven't seen him since February 28th, and I understand that's going to be up to McCaven, but I would just like to maybe hopefully the restraining order be lifted from him so I can at least see him or talk to him.
So that's going to be on the court's docket at 1 p.m. today.
Yes. Okay.
And so and I'm going to be the judicial officer there. So I will hear argument on that issue and make a decision there. Okay.
Thank you.
All right.
Also, if you contact my office, I'm happy to facilitate something. And then is it acceptable to present that order ex parte?
You have been amazing, and I really appreciate the work you've been doing, Ms. Gilmore.
Okay, so contact Ms. Gilmore then, okay?
Thank you, I will.
Sorry, can I present the order ex parte? I just didn't get an answer.
If it was questioning me, ask it again. Go ahead.
Can I present the dismissal order ex parte?
Yes.
Or do you want to? Okay.
I don't want to set a hearing for it. Just submit it to my attention and I'll sign it.
Thank you.
Okay. All right. We're McCaven Mendoza and Lillian Aldrich.
I'm ready.
All right. Ms. Turnbull is here.
I'm here as well.
And Ms. Aldrich is here. Ms. Gilmore is here. I don't know if you're aware, Ms. Turnbull, I heard this on the minor guardianship docket, and I terminated the minor guardianship relating to Maverick.
Maverick.
Yeah. Okay,
Miss Farr gave me a call after that docket, so she let me know.
okay, thank you. So I think we're here today on I guess a visitation plan, or what it says in my docket is a restraining order relating to this case. So I'll let Ms. Gilmore go first. Then I think I'll hear from Ms. Aldrich, and then I'll hear from Ms. Turnsel.
Yes, Your Honor. Procedurally, I would like to note that Ms. Aldrich hasn't been personally served with a restraining order. I received a notice from the clerk's office out of concern for jurisdiction between Oregon and Washington, the service of the sheriff's office. So I do acknowledge that this is a pretty short turnaround, and she does want a continuance to provide a response. In the interim, we are agreeable to non-professional supervision. My client is offering for his mother to provide supervised visitation every other Saturday for a 4 to 6 hour period, just to get some sort of contact going. We would like to see a clean hierarchical prior to visitation commencing. It does sound like from Ms. Farr on the guardianship docket that mother has engaged in a urine analysis. So hopefully we'll be able to get that in short order. But yeah, we're asking for supervised visitation moving forward, or alternatively, just extending the restraining order, keeping the child in my client's care, allowing Ms. Aldrich the opportunity to respond, and then addressing this in another week or two. One last thing, Your Honor. Regardless of the situation, I do think that my client is current primary parent. There is a child support order for a transfer payment from my client to mother. I would just simply ask for a bench order terminating that as of the date the guardianship was entered, and I believe that was at the beginning of February.
So you want to terminate the child support order as of February 1?
Yes.
Let me just write that down. Okay. All right. Thank you. Ms. Aldrich, what counsel just indicated is that Mr. McCaven would be or Mr. Mendoza would be the primary parent. They would agree at this point to non-professional supervised visitations with Mr. Mendoza's mother on every other Saturday from 4 to 6, and request that you do a hair follicle test. So would you like to respond to that?
Well, I don't feel like if I'm thankful for any time I want to get with my son, but I don't feel like one day, a week, every so often is going to do it. I mean, my son has been with me since he was born, and it has been a dual effort as to why he has been absent in Maverick's life. But I'm more than happy and I'm thrilled to have him be in his life now because he needs a dad. But Maverick's used to being in with me. He's with his sister. We have our own situation at home, and as of right now, if this is all we can get so far, then I'm more than willing to cooperate. But I definitely plan on continuing and doing what I best to at least get 50-50 so we can share our child that we do share. And now hopefully I want the restraining order to be maybe dismissed so I can at least talk to my son. I haven't been bugging anyone except for I texted the other petitioners quite a few times trying to get the chance to be able to see them, but I haven't been bugging anybody else around the situation because of the restraining order. And now that anything has been changed or slightly lifted, I'm wanting to definitely reach out with no risk of getting in trouble. I just didn't want to do anything to come in the way of that.
Is there a temporary restraining order in place?
No, it's just the immediate restraining order, and that's not a no contact order. That's just a do not disturb, do not come in the vicinity of. I'm happy to facilitate some sort of FaceTime or telephone call in short order if the court is interested in setting this out and holding off on a temporary parenting plan until we receive a response. I also would just defer to the guardian item. She might have more perspective on that.
Let's go to her then. Ms. Turnbull.
Yes, I think it would be appropriate for Ms. Aldrich to have a hair follicle test and for the urinalysis results to come back from CPS. There are two urinalysis results that are still pending, and we're waiting on those. And so I think that the supervised visitation is appropriate. I also think that we need to make sure that Ms. Aldrich isn't using, and that whoever is supervising the visitation can stop the visit if there's any concern, pardon me, that Ms. Aldrich is under the influence.
I have raised my children both their whole lives, and there's never been a safety concern. There's never been anything as to risk them or anything like that. And even if things had occurred, which they did, and I dealt with that situation at hand, and Washington had the opportunity to pick up the case with CPS, and they chose not to. And after that, things have been different. I've had my son his whole life, and my son I know will like it there, of course, but I feel like this is not what's necessarily best for my son, but I'm willing to do all I can to prove to you guys that I am what's best for my son. And like I said, at least 50-50 was something that I'd be more than willing to be okay with. But my son's home is with me and his sister. And this has already been through a lot, and I want to be there for him and be able to help him and get him to do the things he needs to do. And also remain primary because I've had him his whole life.
Okay, Ms. Aldrich, the issue I think for the court is the court needs objective verification that there's no substance abuse issue.
I understand that, and I've been talking to the other guardian ad litem too, and I'm trying to help them get recent ones as well because of the ones I've been taking. But I don't know why they're taking so long to get back to you guys, but I wish that they would get back sooner so that I can prove to you guys that it's not an ongoing issue.
Okay. I'm not going to enter a temporary parenting plan. I think we need more information in order to do that. I do want this to move along fairly quickly.
Thank you.
I do want to have some contact between Maverick and his mother between now and when we set the next hearing. So I'm going to allow non-professional supervised visits with Mr. Mendoza's mother as a supervisor on every other Saturday from 4 to 6 hours. I'm going to let Ms. Aldrich and Mr. Mendoza's mother determine what those 4 to 6 hours will be. The first one will be this Saturday. I'm also going to require that Ms. Aldrich do a hair follicle test. Today's Tuesday. I'd like that done by Friday. And I'm going to set the next review for April 18th at 1 p.m. And if the UAs and hair follicle tests come back negative, then I would expect substantial visitation time with Ms. Aldrich would be ordered at that hearing.
Thank you.
Okay. All right.
Is the court able to enter a bench order to that effect on those provisions? Just because since the restraining order will be terminated today, then no one will technically have custody of the child. Or alternatively, I can prepare something ex parte and try to get it to the court tomorrow.
We don't have to necessarily do that. I'm happy, very happy. But I also understand that Maverick's most safe and ideal place right now is there, and I can respect that. I'm not sure if the courts can take that, but I can expect and fully respect that is what is going on right now without having to fill out another motion.
For a couple reasons. On my pro se dockets, I do all the bench orders, so I'll go ahead and do a bench order in this case. Also, I'm leaving Thursday and I'll be gone for a week. So if I happen to miss that order, it'll be a while before I sign it. So I think it's going to be safer if I go ahead and do a bench order on those provisions. Okay. All right. Thank you. We'll see everybody back here on April 18th on that case.
Thank you, Your Honor.
Next up is Justin Talley and Zoe Hockman. And this is to establish child support. Ms. Gilmore, where are we at in this case?
So yes, it's before the court on both a motion for parenting plan as well as child support. We originally brought the motion for parenting plan to adopt the current status quo of my client having alternating weekend visitation. Subsequently thereafter, we received a notice from DCS for an administrative hearing. And so then I brought the second motion to address child support in the Superior Court rather than through the administrative process. I haven't received any sort of response from mother in this case. She did appear at the administrative hearing and is aware of today's hearing as that was discussed there, and she received notice. But absent a response, I would ask the court to grant our proposal.
All right, just one moment here. What I have is, if I got this right, the child support would be at $444.22. Is that correct?
Yes.
And as far as the tax exemption, the respondent would have odd years. That would be 2023 forward, and the petitioner would have even years.
Yes.
Okay. Is there anybody else on here on Justin Talley and Zoe Hoffman? Okay.
I did ask for, sorry.
I will agree to that. I don't have an order with me though.
I expected her to appear just because she appeared at the administrative hearing, and I honestly expected her to respond. I would ask for a start date of April 1. This is on our motion, and then the final orders in 2020 didn't address any sort of child support, so I think that's appropriate. I would like to also make the court known, and I thought that mother was going to argue this fact is DCS wants to address back support based on the start date. So I would ask that my client be found to be current as of April 1 on support, and then the support obligation moving forward starts April 1 of the $444.
Tell me more about why the Department of Child Support wants to have a past due.
So it sounds like mother didn't bring up a motion. So the underlying final orders in 2020 reference the fact that either party can bring a motion. It doesn't even necessarily reserve on that. Neither party did so. They reconciled, were living together for a period. And it sounds like sometime between 21 and 22, mother notified DCS that she wanted an administrative order of child support. However, my client didn't receive notice of that request until this year. And so there is a potential back support obligation of some amount that's still outstanding. However, based on the, procedurally, we were before a Superior Court, no one brought a motion. I don't think that it's, and given the fact that the parties frankly live together, I don't believe any back support is appropriate in this case.
Okay. All right. I'll indicate that the mother is current to April 1. The order will begin April 1.
Sorry, Your Honor, father is current. You said
father is current to April 1, and it will begin April 1. And then can you provide a order to that effect?
Yes, I'll enter that Friday.
The last thing is there was a request to change the daughter's name. Is that before the court now? I saw that request in the file.
So that was, yes, that is included in our motion to address both the parenting plan as well as the name request. Again, the final order is reserved on that request. And so I do think we have a basis to make that request now. I'm a little apprehensive given the fact that mother isn't present, some of the concerns procedurally with that. If the court wants to continue to reserve on that, I think that might be fair. And then we can address that on some sort of final basis.
Let's do that. I'd rather have the mother weigh in on that decision. Okay. All right. When the orders arrive, I will sign them. Okay.
Thank you.
Thank you.
A report issued by Ms. Farr. Have the individuals involved in that case, have you had a chance to review that?
Yes, I have.
Yes.
Okay, so it looks like I have both Aldriches here. Is that right?
Yes.
Yes,
Scott Aldrich and Jessica Aldrich.
yes.
And okay, why don't I hear briefly from
Your Honor, I don't see,
Lillian's here too.
I don't see Tracy or Brian.
I don't see them either. It's almost 11, so I think we need to continue to go forward.
They were well aware of the hearing. We just talked about it on the weekend.
Okay. Have they seen your report? I assume they.
I sent it to everybody last night, which I know was late, but I'm assuming that they would have received it. They were waiting for it.
Okay. Ms. Farr, why don't you briefly summarize your conclusions?
So first, I'll apologize for having the report delivered so late, but a lot had happened in a shorter period of time, and I did the best I could to get a thorough report in so that Your Honor had a fuller picture. To summarize, so Brian and Tracy filed the initial petition, and they have had a temporary emergency guardianship of Serenity since the end of February, so about 6 weeks now. And Scott and Jessica filed their petition recently, and they have served everybody that should be served. Brian and Tracy have not served anyone. And I did have a question about the service that apparently the clerk's office prepared a proof of service that I'm not sure was the proper thing to do. So service has not been effectuated in Brian and Tracy's case. Service has been effectuated in Scott and Jessica's case. And both parents have signed the consent to the full guardianship in Scott and Jessica's case. My understanding of the statute is that if the parents have consented and there is no detriment to the child, then the petition must be granted. I have viewed both homes, and I'm going to speak to Scott and Jessica's home because I think that that's the direction that the statute guides us to, and that is that it's an appropriate place for the child to live in right now. Mother is going to enter into some treatment to get some help to improve her situation and be able to come back and request modification and get custody of Serenity back once she's on her feet and able to provide. Father is incarcerated. He is not able to provide for Serenity at this time. Scott and Jessica have been the steady people in Serenity's life besides Mother. And the petition that was filed by Brian and Tracy, I think, was partly filed in bad faith and partly filed of their lack of understanding of the situation and what was being told to them by CPS, and lack of understanding of court proceedings, being pro se people. So they may have perceived certain actions taking place that really didn't, such as they thought that Serenity was being placed with them, which was not true. They were tasked with supervising Lillian, not Serenity was never placed with them. So I know that this is about Serenity, but I just want to say also that had there been a better understanding of the situation, I believe there would be a different outcome for Maverick right now as well. And so that is unfortunate. But going forward with the Serenity, I believe that with the proper paperwork that's been filed, the parents' consents, everybody having been served, that it is appropriate to appoint Scott and Jessica as the full guardian for Serenity.
Just a moment here.
Based on the procedural information, if you need me to go into more detail about specifics of living situations and instances that have happened, I can, but I believe just on the procedural information that we have, that's enough to appoint.
Tracy Hedrick is trying to call in. So I'm going to take a couple moments to see if we can get connected.
I do have a quick question though.
Sure, go ahead.
When would this be like taking place if it was to be transferred into Scott and Jessica?
When would it take place? It might take place today.
Okay, thank you so much.
Tracy Hedrick, can you hear us?
I'm here.
Okay, good. Have you seen the guardian ad litem report or the court visitor report?
Yes, and Your Honor, we would like to ask for a continuance at this time, as this case has taken a different direction after 2 months, and we were not informed until late Friday, the 14th, and we have retained legal counsel, and would like to ask if we could have time to meet with our counsel, as we feel that Ms. Farr's report is very one-sided, and a lot of the facts are incorrect. And even though we have told her some of those facts are incorrect, she never put our voice in this report. So
You're aware that both parents have consented to the Aldriches as being guardian?
That we know of, yes. We haven't seen Miles, as though Miles has told us a different story, so we're not for sure.
Has Miles filed a written consent, or have you seen one? Ms. Farr is indicating yes, he has.
It was filed yesterday and I confirmed it with him. I had a phone call while he was in the jail.
Okay.
But yes, there's a lot of facts in this case that what led up to this point that are not correct.
Okay.
And
well,
we have, in my meeting with Ms. Farr, I explained this to her, but she never put that in her report, so.
Ms. Hedrick, let me read to you the statute, and this relates to the full guardianship that was, or full guardianship petition that was filed by the Aldriches. So this is at RCW 11-130-185. Says a person becomes a guardian for a minor only on appointment by the court. And then number 2, the court may appoint a guardian for a minor who does not have a guardian if the court finds the appointment is in the minor's best interest. And then there's 3 options. The first one is each parent of the minor, after being fully informed of the nature and consequences of the guardianship, consents. And what we have here is this case is squarely within the statute that says the court should appoint a guardian if both parents consent. And based on the petitions, and that's both in your case and the Aldrich's case, I would find that that the appointment of the guardian is in the minor's best interest. But as to who I appoint, once the parents have signed a consent, then I have little, if any, latitude to appoint anyone else other than who they consent to. So I don't know that a continuance is really going to have the ability to challenge that particular fact. Any response, Ms. Hedrick?
Well, just as I said, is that this case was on a complete different direction, and Lily has been making promises and Miles to us. So we're very confused. We did not get legal counsel because we did not know it was going to turn like this late in the game, because no one else has ever said they want a guardianship. And Lily and Miles have all their stuff at our house. So this is all very abrupt to us, and we don't understand why the change and what's going on. And so at this point, we felt we needed counsel because this is all very new to us.
Okay.
Because we were on the understanding it was going differently with Lillian and Miles.
Yeah, Miles isn't even on the birth certificate. We don't even know if Miles Radcliffe is actually the parent.
And that's out of Miles' mouth.
All right, here's what I'm going to do based on the consents that have been filed and the language of RCW 11-130-185. I'm going to appoint Scott Aldrich and Jessica Aldrich, the full guardians for Serenity Aldrich.
Okay, but there's been CPS case in Washington still, and they live in Oregon.
He's already appointed it.
There was a recommendation of appointing, I think Sylvia Aldrich, was it? As a local, I believe I had the note down.
Yes, Your Honor, she was also a co-petitioner, but I think she's better served as the resident agent.
Right, so she'll be the resident agent. The immediate minor guardianship that I had granted in favor of Tracy Hedrick and Brian Fletcher expires today, and I'm not going to extend that. That means Serenity will need to go into the Fletcher's care by the end of today or early tomorrow.
Your Honor, that would be the Aldriches.
Aldrich's,
yeah.
sorry, Aldrich's care. If you still want to meet with counsel, Ms. Hedrick and Mr. Fletcher, within 10 days, you could bring a motion to reconsider that decision. And if you explain to counsel that these consents have been filed, and if they think there's a way around that, I'm happy to have you file a motion to reconsider this decision.
All right. Thank you.
But for right now, the Aldriches are going to be the guardians of Serenity going forward. Do we have an order on that?
There wasn't an order submitted, Your Honor, but I'm happy to help the Aldriches get one to you by email within the next couple hours.
I just have over on an emergency. Are you completely full?
Yeah, I'm looking for a full, so.
And Ms. Farr is acting as their legal counsel.
She's not. She's acting on behalf of the child and advising the court what is in the best interest of the child.
An actual factual
I
basis.
understand you may disagree with her, and that happens, but she is not advocating for the Aldriches. She advises the court what she believes is in the best interest of the child.
All right, that's all right. Look at how good they did with Lily. She's out there running around. We're going to go back into the mouth.
All right, if you can work with them on that order and get it to me, then I'll sign it.
I'll get it emailed over to you. And Your Honor, can we put a timeline for the exchange of the child to occur today?
Yeah, let's do that. The child should be transferred, let's say by 5 p.m. tomorrow.
Tomorrow.
Yes.
And
to whom?
Will that be them, the Aldriches picking her up, or?
To whom, Your Honor?
If you want a specific person, the child is transferred to Jessica Aldrich.
Okay.
At 5 p.m.
Thank you.
Where at?
Can you do it at, well, Ms. Aldrich, where would you like the transfer to take place?
It doesn't matter to me. I'm in town.
Whether you do the high
so
school.
That's perfect.
What was that?
We can do it here at the high school.
Okay, let's transfer at the high school. Is that Kelso High School?
Kelso High School at Gaither Pool.
Okay, so at the front of Kelso High School by 5 o'clock tomorrow.
And Your Honor, will the order address visitation with either parent?
We can discuss that now. Do you have a recommendation, Ms. Farr?
I believe that both parents' visitation should be supervised.
Is there a non-professional supervisor that could be involved, Ms. Aldrich?
Non-professional, I don't believe so. She can be supervised at either my home or at Sylvia's home.
Ms. Lillian Aldrich, do you want to weigh in on visitation with Serenity?
I would just love to see my daughter. I haven't seen her since February 28th.
Okay. Would you have any concern about seeing her at the Aldrich's house?
Absolutely not.
Absolutely
Like no concerns.
no concern. Okay. I am going to accept Ms. Farr's recommendation that it should be supervised. Let's start with a Saturday, like 10 to 2, starting this Saturday.
Okay.
And I will put this back on the calendar in a month in order to discuss increasing the amount of visitation at that time. I want to make
Thank
sure.
you.
And father's visits would be?
It will have to probably be the same thing, although a different day. So he gets.
He's also incarcerated currently.
Your Honor, can I talk?
Just a moment. Go ahead. Yes, sir.
Regarding the father's visits, I believe that somebody else would need to be there to supervise as well.
He also won't even be really asking for it right now as he's going through, like he's in jail right now and he has no communication with any of us anyway.
Okay. If he's in jail, maybe we should address the father's visits a month from now when we come back.
It's a good idea.
So if we could put in the order then that the visits for now are just for Lillian, that would be great.
No, I think we need visitation on our end as well, at least be consideration.
Trinity has resided with us for 2.5 months. She's very
As the
sad.
parent, I would really prefer that to not be happening.
Yeah, we got her off the bottle, we got her off the binky, she's potty trained, nobody did anything for her before.
She was potty trained before she went to you.
All right,
and
we're
she was
not
off
going to
binky
have
already.
this discussion.
We would just like to be able to have visiting. She is attached to us and we are very attached to her.
I'm going to ask.
We love her, she's blood.
Ms. Hendrick and Mr. Fletcher, let's not talk right now. Okay, so I'm going to order the supervised visits at the Aldriches for Ms. Lillian Aldrich from 10 to 2 on Saturdays. I'd like that to be every Saturday if we can do that. And
yes.
Let's come back on, I think it's May 30th. We'll revisit the visitation and talk about the father's visitation.
And Your Honor, am I staying on this case through those visits or you
I
just?
would like you to, could you do that? And then again, Ms. Hedrick and Mr. Fletcher, you have 10 days from today to bring a motion to reconsider. And so I invite you to do that if you'd like to do that.
I would, thank you, Your Honor.
Okay.
Thank you, Your Honor.
All right, I think that's it on this case. Thank you.
So is Brian and Tracy going to bring Serenity to me here at the high school?
Yes.
That's what I'm expecting to happen.
Okay, thank you.
Yeah, that's what you said, that's what we'll do, Your Honor.
All right, thank you.
You betcha.
All right,
you.
that's it on that case. That's the end of our docket.
Burner number 2, the Mendoza and Aldridge matter should be short.
All right, that's 17-3-00101-0.
And I believe Ms. Turnbull was able to make it on.
Yes.
Okay,
I'm here. Thank you.
And so this was before the court, I believe 2 weeks ago, when Commissioner Nelson was covering your docket. He set a review for mother's visitation to determine how we go forward. If you look at the bench order, don't have that directly in front of me, but he subsequently entered a bench order, provided that mother needed to submit a clean hair follicle test by the end of March. I confirmed with Ms. Turnbull prior to this hearing that we haven't received any drug testing for mother whatsoever. My client has voiced some concerns to me. The mother is showing up to visitation under the influence of substances. So absent a test consistent with the court's order, I would be asking the court to suspend visitation until we get that drug test. We potentially could set another review to ensure that visitation isn't indefinitely suspended, but we do have concerns about the child's safety.
And is Miss Aldrich present today? Do not see that name or hear a response. So, and forgive me, Miss Gilmore, so the hair follicle was not done at this point, or has not been done at this point? Okay. Then based on your representation, I feel like that is probably the appropriate way to move forward. So I'll suspend any visitation pending the outcome of that hair follicle if and when she chooses to take it.
Do you want me to submit an order of ex parte, or do you want to draft a bench order?
If you could do a short order ex parte, I will sign it as soon as I receive it.
I can do that. Thank you.
All right, thank you.
Thank you.
That was the last hearing in the case with their son. As of July 2025, Mom still hasn't done the hair follicle test and her visitation is still suspended. The final entries in Odyssey showed the GAL being paid and Attorney Gilmore withdrawing from the case. Dad should still have full custody of the child.
Ms. Farr filed a supplemental report. Did have the parties been able to review that?
Yes. Yes, Your Honor.
Your Honor, I haven't had an opportunity to get my notice of appearance in, but I'll be appearing on behalf of Brian Fletcher and Tracy Hedrick.
All right, thank you. You probably haven't seen Ms. Farr's supplemental report.
I only had an opportunity to glance at it this morning.
Okay.
That it was in Odyssey.
All right. I guess just to summarize where I think we're at is initially the Fletchers requested guardianship of Serenity Aldrich. And then the Scott and Jessica Aldrich also requested guardianship. Both parents filed consents to Scott and Jessica Aldrich under, let me just be sure, under RCW 11-130-185 indicates the court may appoint a guardian for a minor who does not have a guardian if the court finds the appointment is in the minor's best interest and each parent of the minor being fully informed of the nature and consequences of the guardianship consents. Based on that, I granted the full guardianship. Soon after that, the Fletchers moved for reconsideration. I denied that motion based on the consents that I received. And then I received Ms. Farr's current report indicating that, well, let me also say that I got an ex parte motion to appoint an attorney for Miles Radcliffe last week. That appeared to be generated by the Fletchers. I denied that at the time because there was no indication of what Mr. Fletcher's income was, and I needed that before I could determine if he was entitled to counsel. After that, however, I got Ms. Farr's report showing that Mr. Radcliffe is not on the birth certificate, and apparently there's been no paternity action. And the suggestion is that I should dismiss Mr. Radcliffe from this proceeding because there's no legal, there's nothing legally that indicates that he's the father at this point. So that's where I see where we're at. Why don't I just kind of go around, Ms. Farr, anything you'd like to add to that?
The only other thing is that at this point, I believe that Mr. Fletcher is now an interested party and not an actual party to the action. I think that changes some of the dynamics. I did file a supplemental report. Lillian has made some progress. She's participating in parenting Serenity while she's doing her Saturday visits, and I was recommending that her visits are extended. However, she still hasn't provided me the ROIs or done the drug testing or enrolled in the mental health outpatient. And I believe I suggest that she does those things right away. I've talked with her about those things too. I know that she's, trying to, she just started a job and she's trying to establish residency, and she's, making all these strides, and that's fantastic. But there are some of these things that are lingering that still have to be addressed as well.
All right, thank you. Mr. Anagnostou?
Yes, as indicated, I'm representing Brian Fletcher and Miss the petitioners in the guardianship action. There's a confusion with regards to these two cases, because you have the 078 file, which is, my understanding, is an emergency guardianship, and my client's petition for guardianship. They've basically had custody of the children. They resided a lot of the time with my clients, and in this process, they were placed with the other petitioning parties based on consents of the parents, one being the presumed father or alleged father, and he is now indicating, he wants the children Serenity to be placed with my clients. And I understand there's a issue now being on the birth certificate, but that can be resolved by genetic testing. But he's been held out and is the father of Serenity, and it's a new development that they're potentially claiming that because of that lack of his name on a birth certificate, he doesn't have legal standing, which up until this point, he's been held out and been the father of Serenity.
Ms. Aldrich, Lillian Aldrich, anything you'd like to add?
Just that, of course, I would like visitation to be extended as well. I want to see my daughter as much as possible, but that I believe my daughter is good where she's at. She's healthy, happy, safe, secure, and she's with a family that she's been with for her whole life. That I don't want anything to change right now besides the visitation, if possible. I think she's good where she's at, and I don't think that the other parties need to have any part of it. And that Miles should definitely establish paternity before anything gets further with his name.
All right. Either of the Aldriches, Scott or Jessica, anything you'd like to add?
Serenity is doing really well, adjusting, and just a happy little girl.
What is the current visitation now, Ms. Aldrich, Lillian Aldrich?
It's every Saturday.
From when to when?
10 to 2.
Okay.
And I am enrolled in mental health at Columbia Wellness. It's just not necessarily an outpatient program. It's just I just have a therapist. Yeah, and I was hoping maybe that I could possibly be like, because both the parents work, I was hoping to maybe be like the child care for my baby when they go to work or something like that, just so I could maybe see her more. Just that way the baby doesn't have to go to like other people while they're at work. Because I know that there are sacrifices being made and people and they're tending to my child before, their jobs when it comes to some days and stuff like that. And I just want to be able to help with that as much as I can.
And these are being supervised, the visits are being supervised by Ms. Aldrich, is that right? Or
Scott and I.
Okay.
Your Honor, also the current the current visitation says that the supervision is to take place in the Aldrich's home, and they're asking if that could be changed so that it's just under their supervision, so that they're allowed to have visits outside of their home as long as they're supervising.
All right, I want to make sure with both Scott and Jessica Aldrich that what I'm going to propose, it works with you. But I would propose extending Saturdays to 6 p.m. Rather than 2 p.m. and maybe adding a Wednesday afternoon visit, like 5 or 6 to 8, something like that.
That would be fine.
And also, I would add that it can be outside of your home as long as one of you is with the child during that time.
That sounds good.
Those changes sound okay?
Yes.
All right.
Okay.
So we'll go 10 to 6 on Saturday. I'll say Wednesday 5 to 7, and then outside home.
Your Honor, I do have a job and the schedule is not set in stone yet. Is there a way that this could possibly be adjusted according to that schedule before the next court date? If it doesn't, it's because I need to make sure I focus on employment and things like that as well as my daughter.
Well, it sounds like Saturday would be okay. Can you communicate with the Aldriches and let them know? I guess what I'd like is a weekday visit for 2 hours. And if that needs to adjust with your schedule, can the parties work on that?
Yes.
Okay. All right.
So she may end up having to work on Saturdays too, is what she's saying. So what will we do in that instance?
Well, I guess it depends on what your schedule is. The easy thing would be to move it to Sunday. If that doesn't work, then maybe that Saturday is lost and you're not able to really get that back. I think the framework here is a Saturday visit and a weekday visit.
Okay, so do I have the authorization to move that then, or do I need to get authorization from somebody if that needs to happen?
I would say you have authorization if any one of the parties is working on Saturday, then try to work out another date.
Okay.
Thank you.
Okay. All right. I need to make some other decisions here. So right now it appears that Mr. Radcliffe does not have a legal right. And because of that, I think it's appropriate that he be dismissed from the actions. Also, Ms. Farr has indicated that the action ending in 00078 be dismissed. It looks like we filed a full guardianship in both the 133 and the 078 case. And so I'm going to dismiss the 078 case. And out of the 133 case, I'm going to dismiss Miles Radcliffe. Now, that's going to be without prejudice so that if he does establish paternity, he can come back, ask to intervene and be involved again in the case.
So Your Honor, if I could raise an objection,
Sure.
There's been no notice of a motion to dismiss, no opportunity for me to respond to a motion for dismiss. And so I would ask Your Honor not to dismiss it until there was a motion with an opportunity to respond.
Are you saying dismiss Mr. Radcliffe or dismiss the 078 case?
Dismiss the 078 case.
Okay. So you're not objecting to dismissing Mr. Radcliffe?
Well, I am. In this sense, it's been my experience in these actions that the court gives an opportunity in these circumstances for genetic testing to occur.
He's giving him that opportunity. He just wants to do it before he participates further.
I'm sorry, I didn't catch that.
You want to?
It sounds like he's giving him the opportunity. It's just he's waiting until it's proven that he's the father.
All right. I have an abundance.
Yeah, Your Honor, if I may, in
Go
my
ahead.
experience, procedurally, the correct way would be for Mr. Radcliffe to file a paternity action outside of the guardianship proceedings to establish paternity. I've had a few cases that have happened that way. And I guess I'm not understanding why Mr. Anagnostou would be objecting because he doesn't represent Mr. Radcliffe.
Sure, I understand. All right.
Well, I'm objecting because that affects my client's case, the 078 case.
All right, I'm going to dismiss Mr. Radcliffe as a party in both the 133 and the 078 case. I'm going to put the 078 case over 1 month. I guess that's to June 27th. For the purpose of addressing whether that case should be dismissed. And Mr. Anagnostou then and his client can prepare their argument on that issue.
So does a motion need to be filed for that, or we're just going to set it over and have an argument?
I'm going to say today's discussion is the motion, and we'll have that argument then. Meanwhile, the full guardianship in favor of Scott and Jessica Aldrich remains in effect.
Thank you.
Okay, with the increased visitation to Lillian.
Thank you.
Okay. All right.
And I, Your Honor, have another one that I have not put a notice of appearance in yet for. I just came on last night. It is the emergency guardianship of Serena Aldrich, 23-4-00078-08.
Gonna be Serenity Aldridge.
Oh, did I say something wrong? Serenity Aldrich. Sorry, I just came onto this yesterday at around 4:30 p.m.
No, sounds good. And then I do also have a notice of appearance on behalf of Brian Fletcher and Tracy Hedrick on this case. Mr. Anagnostou. Oh, you're muted. Sorry about that.
How's that?
Perfect.
Yeah.
Okay.
I'm on this case. There's two cases pending, the Fletcher's case and the Aldrich's case. We'll probably need counsel to get up to speed on the cases.
Yeah, let me pull up real quick. So this is the one I have on my docket today is 234-0007808. Is that what the parties show as well for today?
Correct.
Okay. When I reviewed this yesterday, it looked like there was the court on May 30th had dismissed a party.
Right.
And now you're appearing on behalf of one of those dismissed parties, Mr. Fletcher, is that right?
The party that was dismissed was the father. That was Miles Radcliffe.
Thank you for that clarification.
He was dismissed, and I'm representing the petitioning parties, the Fletchers, and I didn't realize Miss Winkles was involved in the cases. She is apparently representing the Aldriches.
That's correct, Your Honor. And again, I just came on last night, so I haven't, I have reviewed, and I do have a couple of procedural questions for everybody, or a statement. The first, it appears that a full minor was issued on April 19th, 2023. In the current case that we're talking about, not in the motion that's going to be heard later, on the current case, we have a full minor, which means the emergency, as part of that original minor guardianship, the emergency should have immediately been dismissed. It appears that it was not dismissed. So procedurally speaking, it needs to be. So on this, the motion to dismiss should be granted. And the emergency minor guardianship should be completely dismissed, and it should be consolidated into this. There is a minor. That does not preclude what's happening, Mr. Anagnostou's motion for next week. But in this specific case that we're here for today, procedurally speaking, there shouldn't be a full minor and an emergency going at the same time. unless that emergency was filed after and it was filed before. So I'd ask.
On the other case, you're saying?
I'm saying on the current case before us, this motion to dismiss is actually dismissing, the request is to dismiss Mr. Fletcher's emergency minor guardianship because it appears there are two orders in effect right now. But the one that takes precedence is obviously the order on the minor guardianship that came later. So procedurally speaking, the emergency minor guardianship should be dismissed. And then obviously Mr. Anagnostou is going to be heard on July 6th on his motion to change the minor guardianship. But the emergency does need to be dismissed. We have a full minor guardianship in place.
Let me just pull up, and you said that's being heard on the 6th?
Yes, I believe that's when.
Okay, so let me.
So Your Honor, for some clarification, at the last hearing, what Commissioner Nelson said was that he was dismissing Miles as an interested party, or as a party, and then he set this date for Mr. Anagnostou to file a response as to why the emergency guardianship should not be dismissed. Otherwise, it would be dismissed today.
That helps me understand the notes a little bit better because I did, that's the way I was leaning with interpreting the notes from the last hearing. So I appreciate that clarification. On behalf of Mr. Fletcher, are you objecting to the dismissal of the emergency guardianship?
Yes, I am. And I raised the issue with Commissioner Nelson. There's no motion before the court to dismiss. And counsel is indicating, well, it's automatic. Well, give me a cite to that because I don't believe that's the case. So I was, my issue is there's nothing before the court with regards to dismissing his emergency guardianship, my client's emergency guardianship. And that's the issue that I have with dismissing it.
I think where the court has concerns is that, and I would love your response, is if there now is a subsequent minor guardianship, as I understand it, and I'll be perfectly honest, I haven't fully reviewed that July 6th case, but I understand that there is now not an emergency guardianship, but an actual minor guardianship in place that is subsequent to this. So I think in effect, this has been dismissed. We just haven't done the paperwork. Am I wrong on that?
What it is in the minor guardianship order has a box that is, it's ticked if you have an emergency minor guardianship, and it says that this emergency minor guardianship is dismissed. The numbers are consolidated. That's a box that should be ticked if there's an emergency. There was an emergency here, but the box wasn't ticked. That's where we're at.
Okay. And I mean, so then in the July 6th case, Ms. Winkles, are you requesting that paperwork be corrected, or are you simply saying, well, since that box didn't get checked, we really just need a dismissal on this one?
Yeah, I would love to correct the paperwork, but I think at this point, since it's already there, we just need an order stating that the emergency minor guardianship is dismissed, that the case numbers are consolidated, that the clerk should consolidate them. That way, when we come back on July 6th, it's all one big case. It's not these two separate cases running.
And I am inclined to make that bench order. What is the, I want to make sure I get the case number correct, because we'll consolidate into the July 6th case number if you have that handy.
Mr. Anagnostou, do you have that handy?
I do. I'm getting the right one. 23-4-00133-08. And I believe the guardian ad litem, Sherry Park, could confirm that too.
That's correct.
That is correct. Okay. And Ms. Farr, do you, again, having been involved in these cases, do you have any objection or issue with court issuing a bench order to that effect, dismissing this emergency minor guardianship and consolidating into the 13308?
No, Your Honor. So in the report that I filed in the 078 case recommended that that case be dismissed because the petition for the on the standard petition was being approved and the full order was being put in place. And that's Commissioner Nelson was going to dismiss that day, the last hearing. And that's when Mr. Anagnostou objected. And so he gave him until today to file his reasons for the objection, or it would be dismissed today. And actually under section 15 of the minor of the findings, it says to the clerk, terminate any linked emergency guardianship cases, including under 23-4007808. So it was in the findings.
Okay. That is helpful too. I am gonna, just for sake of clarification, since it sounds like maybe some of the paperwork did state dismissal, maybe some didn't. I'll issue a bench order based on our discussions today that does formally dismiss this emergency minor guardianship. We'll consolidate it into the 13308. Okay, that'll be my ruling today.
Thank you, Your Honor.
Okay.
All right. And then I'll just stick with Ms. Winkles and Mr. Anagnostou with the guardianship of Serenity Aldrich, 23-400-13308.
Yes, Your Honor. I'm asking that this matter be set over at least a week or potentially 2 weeks. I received substantial documents in response to my client's motion. Basically, yesterday I received them, some on Monday, and then Miss Winkle's stuff late Monday. And so Tuesday was a holiday. I need time to respond to their numerous documents that I received.
And Your Honor, the only reason that I'm asking for no continuance is procedurally, the motion is incorrect. In a minor guardianship, if you are going to change custody or change visitation, there has to be a number of things in place. First, it's a petition. It's not a motion. It must be personally served on the parties. It's absolutely not a motion that's in the statute. That's actually on the pleadings themselves. It cannot be mailed. It must be served under CR4. So it has to be personally served. So there's been no service in this case. Second, Mr. Anagnosto's clients have no standing. They're not family members. They're quote unquote interested parties. Adoption of the child's mother out of Mr. Fletcher's hands and into a different parent cut that tie, which means that we look at the criminal history of Mr. Fletcher, we look at the criminal history of the other party, which you wouldn't necessarily do if it's family. They both have criminal histories which preclude them from asking from being guardians at all. Now we'll see an Oregon report that essentially says that they're clear. That's not the case. It's Brian Thomas Fletcher from 1969. You'll see in Mr. Anagnostou's report, there's no middle initial. Brian Thomas Fletcher. That has to be in Oregon with middle name, or it comes up as nothing, which is why we gave Your Honor the Oregon felonies. It's 21 felonies in total, and the watch report. It means Mr. Fletcher has no reason to bring this case. He is completely precluded. He's not a family member, and he's been convicted of a felony, including theft, dishonesty, or assault. So as Miss Tracy Hatfield Hedrick. And that precludes them anyway. On top of that, it's res judicata. The final minor guardianship order in the case was entered on April 5th of 2023. That was like 6 to 8 weeks ago. So unless something has drastically changed in the last 6 to 8 weeks, this issue is precluded. There's no new information in the motion. This is purely a procedural issue, which is why I didn't want to continue it. There's no new information there. We want to see this child. We want this, we want that. We love this child. Maybe they're doing this, but we don't know. The fact is that's not enough. There's no information. It's already been decided. There's been an order at April 5th. This is another attempt at biting the apple. They tried to do a motion for revision that didn't succeed. They apparently did not try for a motion for a new trial. But in any event, it's been done. It's done and dusted. So the only way they can get visitation rights is through the petition for visitation, which exists under the statute, but Mr. Fletcher is not the child's grandparent. He lost 3 of his children to a dependency action. They then went on to have other kids. When he lost those children and they were adopted out, his parent-child relationship was severed, which means he's not the grandchild or grandfather of anybody in this case. My client is, because he adopted the parents and now they have their own children. So I'd ask for no continuance. I'd ask to strike these pleadings. I actually asked for CR 11 sanctions, and then I don't think Mr. Anagnostou, not against Mr. Anagnostou, against his client, and also under the frivolous statute. I don't think they told Mr. Anagnostou that they had 21 felonies. And because of that, and thus he brings this thing forward saying that his clients are clean of criminal activity. That's not the case. There's a reason they lost their children in the first place, who then went on to have children, and that was severe neglect and abuse of these children in the state of Oregon. It's in Washington. It was decided this, even if you vacate after you're on DOC because of COVID, it doesn't mean it goes away. It doesn't mean that you were never convicted. What it means is it was vacated after the fact so you can get your weapons back. It still means that you are precluded under the Minor Guardianship Act if you do not have a relationship, a family relationship with the child, and adoption severs any family relationship. Thank you.
Thank you, Ms. Winkles. Ms. Farr, I know you wanted to weigh in. I'm assuming it's similar to the last case.
Well, actually, Your Honor, I agree with Ms. Winkles, and Mr. Anagnostou filed his motion on June 27th. I responded on Friday, the 30th. I believe Ms. Winkles responded on Monday. There's been plenty of time for Mr. Anagnostou to review the responses. If he didn't schedule it in enough time to allow for a second response from him, that's not on us. And this, one of the concerns I have is because this action is brought in bad faith and inappropriately, the taxpayers are fitting the bill for my services on this, and they shouldn't be. This matter is done and over with. The guardian was put in place. The only ongoing issues right now are mother's visitations. That's the only reason I'm in this case. And the motion should be denied. And as Ms. Winkle said, the Fletchers are not parties to the action anymore. They don't have a right to keep interfering.
All right. Any response to that, Mr. Anagnostou?
Yes, Your Honor. The guardian ad litem, I have plenty of time. I got this yesterday. Ms. Winkles didn't respond until like 4:30 on Monday, the day before a holiday, and I didn't get this until yesterday. And I've had opportunity to meet with my clients, and I can respond to all these statements and allegations. I just haven't had time. They bring up my client's past criminal history, but when you look at this, the document they filed, it's false ID, back in 2005, dismissed. A second one in 2005, dismissed. It goes count, 2, 3, and 4, all these allegations. It looks like there's a lot of allegations, filed against my client. These are all dismissed or vacated. I don't know if these have different dates on them or if they're the same thing, but they've dropped a bunch of paperwork on the court of dismissed allegations, against my client from 2004, almost 20 years ago. Here's a identity theft dismissed. And then it says identity theft 3, 4, the pages go on and on and on. And I can point that out to the court. What they filed is inaccurate, and their allegations are inaccurate. I just haven't had time. I need some time to respond to this. There's other allegations. This is not frivolous. I disagree with counsel. When you look at the statute, this is RCW 11-130-050, I cited it in my motion, says that the court at any time may appoint court guardians and co-conservators. I haven't had an opportunity to go, in detail through Miss Winkle's stuff since I got it yesterday, basically, to respond that, my clients are named interested parties in the Aldridge's action. They're named interested parties. They're asking, they're pointing out to the court that they had significant time, they had custody of Serenity, and they're asking for to continue that relationship. They believe it's in her best interest that relationship be continued. And we would like to present that to the court. Why that's important to Serenity, this young child. But I need to respond to all this stuff because it's a smokescreen to deflect the issues.
And you're on one word or two word reply, res judicata. We've already been here. There's a final order. It was decided. Unless there's something new from April to now, which there's nothing in any of those pleadings, it's precluded. And it's just another bite at the apple.
And I guess, Mr. Anagnostou, there was also just basically there needs to be a petition, not a motion. Any response to that portion?
Well, again, I'm looking at RCW 11-130-050 that says the court can set rules at any time, and it's I'm looking to see if it says specifically upon a motion of any party or the court itself can do that. I don't believe it requires a petition. We are not modifying the guardianship. We understand that the court granted guardianship to the Aldridges. My clients are interested parties in that action, and they're asking the court for the benefit of the child that they be allowed to see the child. They had the child up until the court granted custody to the Aldridges. And they're presenting that to the court by way of a motion. I don't see where it's required that we file a petition when they're interested parties and have been involved in this action, but I haven't had an opportunity to brief Ms. Winkle's response.
It is a mandatory form that's available from Washington court forms. It is a petition to change or modify a minor guardianship. Anytime a guardian is changed, according to statute, anytime visitation to others is changed, anytime that there's a change in any effect minus parenting, even when it comes to visitation with the children, as long as that issue has not been continued and been allowed to be open, and it is in this case with the mother, then the proper method forward is a petition to change or terminate a guardianship. That is a mandatory form that is available in Washington court forms, and it clearly lays out the service standard of that document.
So I agree with Ms. Winkles. The criminal history part, frankly, I haven't had an opportunity to review. I don't. It appears that Ms. Farr and Ms. Winkles are on both of the belief that these parties are precluded based on those criminal records. You're saying that criminal records have been either expunged or those folks were found not guilty of those crimes. Here's what I'm going to do. I'll set this over 1 week for a response to the 13th, 10:30 a.m. Frankly, Mr. Anagnostou, in my brief review of the record, I tend to believe that Ms. Winkles is correct in this assertion. And if she is correct, then it is concerning because it may appear as though the parties have misrepresented themselves to the court. So any requests for fines or fees will be reserved to next week upon the court's ruling. But I'll give you 1 week to respond to everything that was filed by Ms. Winkles.
Thank you.
So we'll set this to the 13th at 10:30.
Thank you, Your Honor.
Thank you.
I did have an opportunity, just so everyone knows, I did have an opportunity to read through the vast majority of the file. And I read both in the 13308 file as well as the 00078 file. So I read both files to have a complete understanding of where the case is and sort of where the case has been. It's my understanding the cases are now consolidated by court order, but I just want to make sure that there was nothing missed. So with that, Mr. Anagnostou, it's your motion.
Right, correct, Your Honor. It's my motion for visitation for my client, and you got my response to my reply to counsel's response.
I did. So I received a copy of bench copies, including a declaration of Jeremy Aldrich. I received your response, and there was a couple additional sealed materials that I reviewed, as well as declarations of your client, or a supplemental declaration of Mr. Fletcher.
Perfect. I just wanted to make sure you had everything. And so I guess my initial question is, you know, my motion is before the court. Counsel has objected procedurally. Do you want to take up the procedural issue first, or do you want me to argue regarding visitation for my client?
I think the main issue is the procedural one, so you should address that.
Okay. Well, with regards to the procedural issue, and in response, we filed our response. Counsel is misstating where we're at in this case. Where we're at in this case is that my client would file a motion for intervention, but he doesn't need to. He's a party to this action. And intervention clearly indicates that it's done by motion. The facts would support him being an intervener because he had custody, had placement of Serenity in his home at the time that the Aldridges started their guardianship action. He had to be a party. He was a necessary party because the court had to have jurisdiction over him to issue an order that he return or turn over Serenity to the Aldridges, which is what the court did. So I think it's just clear. My client's a party to this action. He's a party. He was served, and he was ordered to turn the child over. His visitation rights, although the petitioners alleged in their petition that he had visitation rights and that he's an interested party, those were not decided. They have not been decided. There's no res judicata issues regarding his visitation rights. So procedurally, I think we're here appropriately. My client brought a motion in this action. This action, as between both my clients, Mr. Fletcher and Ms. Hedrick, as from their position, is identical to the Aldridges legally. This isn't a Troxel case. Where you have a biological parent who has greater rights, constitutional rights. This is two parties that are on equal footing. My client had placement of Serenity, and now the Aldridges have placement of Serenity, and as between them, they're on equal legal footing. And my clients requested some visitation rights, and we think it's important that those be granted to for the benefit of Serenity. We set forth the declaration of Tracy Hedrick from when we filed this motion, pointing out the very close, loving relationship she has. The response by counsel, she raises various issues with regards to you have to be a parent. In particular, they raised RCW 2611. That doesn't apply. It just doesn't apply. That's a statute that is basically in response to the Troxel decision, and it indicates that a relative, and they're saying my client. So basically, it's a straw man argument. They say you have to bring this under 2611. We can't. We couldn't. That's that statute. is 2018. There's only been one case on it. I take a look at it. It was a grandmother who was seeking visitation rights with her granddaughter from her daughter. And the court said, you know, you don't have standing and you're going to, and when they talked about standing, it was, you have to prove certain elements in order to go forward under that. It's against a biological parent. I believe they awarded attorney's fees in that one case, but this is not that case. That's a straw man argument, Your Honor. My clients are parties to this action. They had placement. There was an indication that in the petition that visitation, other parties who have potential visitation rights, they were listed as that. We're here to seek those. They haven't been decided yet. And the petitioner's objections are just not applicable. They've claimed res judicata. That's not applicable. RCW 2611 doesn't apply. A modification, we're not seeking a modification of the guardianship. I believe my client's motion is appropriate before the court. It concerns serenity, which the court has jurisdiction over. It concerns two parties on equal footing and what we should do going forward. And so I would ask the court to not grant the requested relief in the petitioner's response and to grant some kind of residential time. I'm not sure if you want me to switch gears and go into the visitation or if you want to hear from counsel regarding just this procedural issue first.
Well, we're going to address the procedural issue first. So wouldn't you agree your clients were present at the April 18th hearing where the court discussed and made decisions regarding the child's placement as well as guardianship?
Yeah, my clients were present.
Didn't they have an opportunity to be heard about visitation at that time?
That was not the issue before the court at that time. So the parents had signed documents switching, basically making their recommendation as to who they would want placement, where they would want Serenity placed, and the court accepted those under the provision that allows that in the statute. RCW 11-130, and I'm not sure of the specific site. I had that regarding parents being able to direct where a child who has guardianship. That was the only issue before the court at that hearing.
But wasn't that the time to bring up visitation requests when the court was making placement decisions?
Well, it could have been, but I don't think it's mandatory. It wasn't. My client's rights were not discussed during that hearing.
Well, didn't the court take the child and dismiss your client's action and place the child with other people? It seems like your client's rights were discussed at that point, and the court made orders at that point.
My client's action wasn't dismissed. It was later consolidated into their action. That only happened a week ago or so. Well, late June, a couple weeks ago. I think I have that.
Says the emergency minor guardianship is dismissed, and this cause number shall be consolidated with the 13308. So that looks like a dismissal. Yeah,
I understand, Your Honor, hanging your hat on the first part of the sentence, and my position is the second part of it. It was dismissed and consolidated into the Aldridge's action.
Didn't subsequently to the court placing the child with the Aldriches, your clients file a motion for reconsideration, which was heard and denied by the court?
Correct, and that was in their emergency guardianship petition on an emergency basis, which is, yeah.
Isn't the motion that you filed, you requested to be co-guardians?
That's alternate relief, correct.
Hasn't the court already ruled on guardianship at this point?
Yeah, they have, and RCW 11-130-050 indicates that the court at any time may appoint co-guardians. That's what it says.
isn't your request essentially to modify the child's current placement?
No.
How so? Aren't you asking for visitation?
Yes, we're asking for visitation. My client's parties to this action that it has not been heard before the court. And so that we're asking that it be heard.
Do your clients qualify to be guardians of the child? Like, could they even qualify? Let's say this child is just in the wind. Could they even qualify to be guardians?
I believe so. They have raised all sorts of criminal backgrounds on my client, Brian Fletcher. And as we pointed out, they were dismissed, and he has filed basically what's equal to the watch report here, the Oregon reports regarding his background for both he and Tracy Hedrick. They have no criminal background. But again, Your Honor, that's an alternate request. That's a request under RCW 11-130-050, where the court has authority at any time to appoint a co-guardian, we think, or a co-guardian. And my client's primary request to the court is to be able to see this child, see Serenity. They have a close, loving, bonded relationship, and as she does with them, they're her grandparents, even though legally my client is not a parent or grandparent, but biologically he is, and the mother has maintained a relationship with her biological father and family, and my clients are on equal footing with the Aldridges. This is not an RCW 2611 case. And we think it's important that the court consider, there's been references that this issue would be resolved by agreement, but the Aldridges won't talk to my client.
Are they required to agree?
No, absolutely not. That's why we bring motions.
All right. Ms. Winkles, I get to give you an opportunity to argue. I'll tell you a couple of things that don't matter to me. In this matter, Mr. Fletcher and Mr. Ignacio's clients, that I would argue they're fictive kin. They're not biological, or I should say they are biological, but legally not related. I think that doesn't preclude people from being interested parties or parties in and of themselves in these types of actions. So those arguments, I understand why they were raised, but they also don't sway me. Just sort of, I don't think that they really rate just based on how the law plays out in this area. So with that sort of caveat, I'll let you go ahead and make your argument.
So the only reason I brought those up is if you are a non-family member, you cannot have been convicted at any time of a number of things, including assault, neglect, or crimes of moral turpitude. And the fact is while these were DOC vacated, these 21 felonies, they were not dismissed. They went to trial. He was convicted. And so in order to have those felonies overcome, he has to be a family member. And he's not by law. That's the only reason I brought that up. But in reality, we don't even get to that point. There is a full minor guardianship order in place. That minor guardianship puts my client in a much better position. It puts my client in the position of a parent. It is essentially saying to the world that this is the person acting in the stead of the parent. That means he has the right to determine visitation, except for anybody who has a constitutional right to their children, which is why the court continues to have a fluid relationship with the parents, and visitation increases. But any third party, just as a parent would, they can deny. Now, the only way out of that is to use RCW 2611, which essentially says you can petition, pay a bunch of attorney fees, and try. Mr. Anagnostou knows that his client doesn't want to pay attorney fees. It's likely that it's going to lose. Our county hasn't done them. There haven't been many done because you have to pay all these attorney fees. So what's happened here? We've had a final order entered. They had their petition. They sought guardianship as well. Mr. Anagnostou's clients, they lost. The child was placed with my clients. Visitation was determined at that point. It was determined for the parent to have a right to the child, and my client was put in the other position. Mr. Fletcher may be a quote unquote interested party, but he has no legal right to this child. And that was decided because he attempted to have that. And it was decided, and he tried to get a reconsideration. And it wasn't just a reconsideration on the emergency. You'll notice that the minor guardianship order came, and he did the 10 days of that order. He reconsidered the minor guardianship order. Now, Mr. Anagnosta brings up 11-130.050 as his basis here, that you can appoint a co-guardian at any time. He doesn't read the rest of that. A co-guardian can be appointed to serve immediately when and if one of the events occurs or the co-guardian complies with, and it gives this other statute, 040, which is not at issue here. The event that's occurring is the incapacity of the guardian, is the death of the guardian or soon to be death of the guardian. The events that we're talking about here are significant, and they mean that the person is either going into surgery, long-term surgery. It mentions a bunch of these different reasons under the standby guardianship as well. These events are significant. That hasn't occurred. This order was entered in April. There's been no change in circumstances. According to Washington practice, which is not binding, but it's just a little influential here, it is very clear that it states that when you have a custody order, and that's what a minor guardianship is really custody order. When you have that, in order to make a significant change in that, there has to be a significant change to the child or the people with the child. And Washington practice quotes that as being appropriate in these cases as well. And it really is. There's no reason. It's been April. They've had another bite at this apple already. They tried to get the emergency. They didn't get it. Nothing has changed since April. My clients, they're trying to pull off this other thing. These people adopted Mr. Fletcher's children a long time ago because he was arrested for severe neglect. He lost 4 of his kids. And these kids, one of them had this child and is a grandchild. But it's not Mr. Fletcher's grandchild. It's my client's grandchild who raised Mr. Fletcher's kids as his own birth certificate and the whole lot. The fact is, we've already been here. Procedurally, it's absolutely incorrect. And furthermore, it is a modification, which requires a petition and personal service. You don't just get to choose to do a motion because it's easier. You can't just suddenly call yourself an intervener when the court case is closed because there's been a final order in place. They had the ability to do a motion to intervene when the case was active. The case has a final order in it. That whole question of who's guardian, that was decided in April. I would ask for CR 11 sanctions. Frankly, this is just a third bite at the apple now. It's procedurally absolutely incorrect. Service hasn't been made appropriate. My clients have had to pay me to come and argue this. And there is another act. It's called RCW 26 that allows them to try to get visitation if they so desire. They will need to pay my client's legal fees for that up front. That's the way we do it. If they can't afford that, unfortunately, they can talk to Mr. Aldrich and try to be friendly and become friends with him, because right now the court has determined he is the best person to make the decisions for the child. That's what they determined in the minor guardianship order. And just like a parent, you get to choose who you want the child to be around. I'd ask that Your Honor deny the motion with prejudice and give my client attorney fees for having to be here. Thank you.
All right, Mr. Anagnostou, any response?
Yes, Your Honor. The comment that my client is seeking a significant change is not supported by law in the state of Washington. I cited a case regarding that. Now, the case is a dependency case. And in the dependency case, on page 4 of my brief at the top, I've quoted the case. MS argues JR's permissive intervention substantially alters the status quo because he's not a parent. And then it goes on. And the court ultimately, this is their ruling in that case, granting JR party status as a permissive intervener to move to de facto parentage does not substantially alter the status quo because JR was already, and then it goes on for there. So my client's request for visitation with Serenity does not alter the status quo that the Aldridges are the guardians. And my clients are parties to this action. They would have brought a motion to intervene, but they didn't need to. We brought the motion to establish these visitation rights. They haven't been determined before. They bring up criminal records of my client. It's interesting they don't bring in Mrs. Aldridge, who has apparently some criminal history background, and she surprisingly isn't here today. We point that out. They have somebody living in their household in addition to her that potentially has some criminal history going on. But, my client's stuff that he took care of 20 years ago, and is all vacated or dismissed, they're hanging their hat on that. And, the guardian ad litem indicated that there's some kind of potentially drug use by my clients. So they did hair follicle tests and submitted that to the court. They're totally open. This is the point. We have a child who had a close, loving relationship with her, and considered, although not legally, considered them grandparents. We think it's important in this guardianship that relationship be maintained, that she's being harmed by not being allowed to see. Setting up a straw man, you should have done this motion or brought this petition that is ultimately going to lose and not supported by the law is not what we're here to do. We want to benefit the child by this motion, and that's what our request is to do. And we think it's appropriate, and it hasn't been considered by the court up until now.
Ms. Farr, I see you there. Would you like to provide input?
The only thing I would add, Your Honor, is that the findings that were entered in April dismissed the Fletcher's case under Section 15. So I don't really understand why the cases were consolidated after that, because that terminated that linked emergency.
I really take
case.
issue with guardian ad litem giving legal opinions, not previously.
I asked for it.
Okay, well, I'm just raising my objection.
All right, fair enough.
So that's one issue. The second issue is when the mom signed the consent, she does not want the Fletchers to have any contact with her child. She still doesn't. I just talked with her a couple days ago. So both the guardian who is appointed and mom do not want the Fletchers involved in that child's life.
All right, give me just one moment. So
The only other thing I would add, Your Honor, is something that I think is important for the court to know, and that is the only reason the Fletchers had the child in their possession was because they filed the emergency action ex parte, and it was granted ex parte, and it was done under false pretenses. And so I just, that little less than 2 months that they had serenity probably shouldn't have happened. And that's really the only connection they had with that child. According to the mother says that all of the assertions that they have been in Serenity's life is false, that she does not have a connection with them at all. So that's all I would say, just those three things to consider.
I appreciate everyone's arguments. Again, I did spend time reading this file, going through clerk's minutes, going through this file. They said that both of the court files and looking at them, it's very clear that the court looked at both of these folks as potential guardians. The guardian ad litem, Ms. Farr, looked at both homes. Even I think her report even references that. And so the idea, and the court chose very clearly that the only guardians it was appointing were the Aldriches. Subsequently, there was a motion for reconsideration and a denial of that. And now subsequent motion saying, no, appoint me co-guardian. That's not appropriate. The court made a ruling, and you can't just refile another motion and ask for another bite of the apple. That is what that is. The statement that you can do it at any time, but not when the court's already made a ruling. And in this case, the court clearly had. And so I do find that the court very clearly made a ruling on that. That ruling was not, there was no equivocation on it. Everyone was aware of it. When you file a motion for reconsideration, it's not because you don't understand what happened. And so this is trying to relitigate that issue. So I think the first issue really is the raising of the co-guardian. I'm denying that. That's not appropriate. The court's already ruled. And I'll address sort of subsequent issues on that. On the issue of visitation. So there is a request for visitation. Again, I did read the clerk's minutes. Both of Mr. Anagnostu's clients were present at the time of the hearing when the court was making its ruling about visitation. There's the subsequent order appointing minor guardian goes through in detail what mom and dad's visitation is going to look like. If there was going to be visitation, that was the time. The idea that we complete a case, we close a case and we move on, and at any point, an interested person can just come along and say, well, I didn't speak up, or I didn't, or I did, and the court ruled against me. And so I'm going to subsequently obtain a lawyer and then file a motion, isn't appropriate. Second, there's a limit to how many slices of time a child has. In this case, the child has her primary caregivers, which are the Aldriches. It sounds like there's visits happening with mom. At some point, there'll be visits happening with the father. The idea that we can just apportion time to everyone, I think, isn't appropriate. There has to be a limit. And that's the purpose of a guardianship, is that those people, other than the parents who have very clear constitutional rights, that we're not going to sort of slice and dice a child's time between a whole host of other people. That's really the job of the guardians. And hopefully, eventually, the job of the parents, if the children are ultimately returned to the parents, to make those determinations and those calls. And so at this point, I'm denying, I don't think it's appropriate. I don't think the motion's appropriate. I did read it in its entirety. I understand people are bonded. I understand that people have relationships. The purpose of the guardian is to make the best determinations for the child. So I'm denying any requests there. I'm not making any finding on whether or not, I think the court already made its ruling, but even if subsequently the court says it didn't, I don't think it's appropriate. Again, we already have visitation to both parents to contend with and the Aldriches. Three hands in the pot is enough. I think adding additional folks would only cause complication and then cause issue with the parents' constitutional rights. So where that takes us. So that takes us to a place where I've said the first motion, which was to be appointed co-guardian, was inappropriate. And I'm denying the request for visitation based on A, I think the court already ruled, and B, I don't think it's appropriate. So Ms. Winkles, with the understanding that I've sort of agree in the sense that the request for co-guardian was inappropriate, what's your request for fees regarding that issue?
My requests for fees regarding that are still obviously the baseless filing because of res judicata. My request for fees for just that part without the visitation, which is one of the reasons we did not file a response to the request for visitation, minus one filing of the text messages. My request is for $2,500, which is the amount of attorney fees. It's actually $2,732.76. And I can file those, but I think $2,500 to take care of the text messages and any argument we may have made today on the visitation.
Okay. So with that, because I do find I'm not, I am going to order fees of $2,500. I find that that's reasonable. I think that the Mr. Anagnostu's clients, they were well aware that the court had made its rulings and pushed forward on that issue. I think that they were also aware, but I'm basing that essentially on the request for co-guardian when clearly that's not appropriate here. So, okay, that is my ruling. Anything further from you, Ms. Farr, on this matter?
No, Your Honor.
Anything further from you, Ms. Winkles?
Just that I'll be filing my affidavit of attorney fees that go along with that number.
Very good. Anything from you further, Mr. Anagnostu?
No.
All right, very good. So with that, I don't have a set presentation date. And so if the parties can't agree on the form of the order, just reach out to the JAs. And you should be able to find and agree. We'll propose a couple dates and make sure something works for both of your schedules.
Thank you, Your Honor.
All right.
Then the guardianship of Serenity Aldrich, let's call that matter next. This is cause number 23-4-13308. Here we should have Ms. Winkles present, and we also have let's see, there's probably a variety of people that are here. Ms. Farr is present as the guardian ad litem. Lillian Aldrich, are you here?
Oh, this is an adult side. And Your Honor, I wouldn't expect anyone else. Unfortunately, we noticed late that it wasn't Ms. Baldwin. So I need to put that on her presentation docket, although Mr. Anagnostou has already fulfilled a bunch of conditions, so I probably need to change those orders anyway, and I'm sure Mr. Anagnostou will just sign off on them.
Right.
Okay.
Yeah, if we get to amend the order and delete the judgment because it's been paid, and we should be able to get that entered by agreement.
Absolutely.
All right. So let's look at setting that Commissioner Baldwin's presentation docket. If the parties make the tweaks and sign off on it, then we can sign off on it, then we can strike it from that docket.
Sounds good.
Let me check with Madam Clerk regarding Commissioner Chelsea Baldwin, correct?
That's correct.
As far as that docket, do you know when that docket is?
So they're usually run on Tuesdays, but she would have her availability, so it'd probably be best for parties to know that.
Good. Thanks. So in consultation with Madam Clerk, she indicated that generally her presentation docket is on a Tuesday. However, that changes week to week. And so she advises the court administration when she has availability. So might I suggest that, and this comes from the court clerk, to the parties could note it on and that particular docket. And then I think at that point, if it's noted on, then that docket comes. And if she's there, great. If not, then go from there.
Sounds good, Your Honor. Thank you.
Thank you, Your Honor.
Okay, great. We'll proceed in that fashion. Thank you both.
Sure.
Thank you.
5 months later.
All right, that brings me to number 7 and 8, 2449-08. This has to do with Serenity Aldrich. Who do I have present on that matter?
Aaron Winkle's appearing on behalf of the petitioner, Scott Aldrich.
Okay.
And I believe Mr. Radcliffe, who is now the father based on genetic testing and through a DCS action, is also here.
Okay.
On appears Lillian Aldrich, who is the mother, is also here.
Miles, I didn't say it loud. Okay, Mr. Radcliffe, I'm going to mute you. I'm not sure who's talking off on the side, but it needs to stop. All right. Anyone else on this matter? Okay. All right. So, Ms. Winkles, go ahead.
Yes, Your Honor. This is kind of a strange one. Miles Radcliffe was the father. There was a DNA test done. He was not included in the original petition. So I guess he was included. He consented, but then they found out he wasn't on the birth certificate. So then the Department of Child Support obviously did what they were going to do, the state. They did get him on the birth certificate. So we're here now, given that mom is the only one that's under this guardianship and the rules of the guardianship. We normally let dad go ahead and do this and do a motion, but we do want to make sure that there's no confusion when it comes to the school or the police or any of those things. So we did want to include dad on the guardianship. He has not responded to the best of my knowledge. I'm assuming Mr. Gaudet represented him in another matter. I'm assuming he's going to be asking for counsel and to set this over today, but I'll let him speak.
Okay. So, Mr. Radcliffe, go ahead and unmute.
What's the thing I filled out? Declaration. I filled out a declaration and I turned it in today because I really didn't know what it was about.
Okay.
I was misinformed about what it was about.
Mr. Radcliffe, I'm going to stop you for just a minute. Let me ask you this. Do you want to have an attorney appointed to represent you?
Yes.
Okay. So can you give me an idea about what your monthly income is, just a general amount? Are you receiving any benefits or anything like that?
I literally just got a septic job. And so it's only part-time, so it'll probably be like, I don't know, probably like 500 a week.
Okay. All right. So you would qualify. So I'll go ahead and appoint an attorney for you. Sounds like maybe Mr. Gaudet had represented you before. Is that right?
Yeah, and if I could get him, that'd be really cool.
Okay. I don't know if he'll take if he'll take any more cases right now, but because of that, I will go ahead and have my assistant reach out to him to see if he would take the case. So it takes a bit to locate an attorney, so I can't tell you who that's going to be today. But would you like to talk to your attorney before we do anything more today?
Yeah.
Okay. All right. All right, so I'll go ahead and do that. We'll try to get somebody on board for that. And then we have, looks like Mom is on here too. Lillian Aldrich, is that right?
Yes, and Mom's already consented in the past, so that's the minor
okay.
guardianship. She has visitation.
Okay,
already.
all right, good. All right, so has a guardian ad litem been appointed? Are you wanting to go ahead and do that, or?
Sherry Farr is already the guardian ad litem in this, and
Okay.
she's still on. She was not discharged, which is why I actually spoke to her yesterday. So that's how I know about her internet issues. So
Okay.
I'm assuming that's why she's not here. And so I can just let her know that Mr. Radcliffe's been appointed counsel.
Okay. All right, so my thought is to go ahead and set this over to February 1, so we have a chance to get an attorney for Mr. Radcliffe. And Mr. Radcliffe, just to find out, is your contact information in the court file?
Yeah, I just filled out what is it? A declaration. It has my number, my address, and everything on it.
Okay.
And,
okay, super. All right, that's what I need, and I just want to make sure that your attorney can get a hold of you.
Yeah. Can I just ask something real quick?
Go ahead.
I have not been able to see my daughter because whatever the guardianship said that I wasn't aware of, I have not been able to contact my daughter, call my daughter, see my daughter, have anything with my daughter. It's been like what, 8 months now.
Okay.
And I'm not expecting like oh yeah, you get it overnight. I just want to know if I can visit my daughter in any way.
So at this time, I don't know who's talking off on the side. Please stop. Okay, you're not an attorney. I can't have you saying telling him what to say. So, sir, you're going to get an attorney, and I'd like you to talk to your attorney about that. I don't know enough today to say yes, you can, or no, you can't. I don't know enough. And that's where the guardian ad litem, she couldn't be here today, and she'll make contact with you too. Do you understand what a guardian ad litem is?
Yeah, isn't that the person that comes to like see the house or whatever that I stay at?
Exactly. Exactly. So her name is Sherry Farr is her name, and you may be hearing from her as well. Okay. So, but let's go ahead and get an attorney on board. I'm not saying yes or no to visits. I just don't have information, and things can't happen that quickly without my information being in front of me. Okay.
All right.
So we'll look at that later, but for right now, that's not going to happen today. Okay.
And Your Honor, I just asked that the emergency that's in place, I think we asked for an emergency restraining order just until the hearing. I asked that continues since we don't know anything either. And I know Dad has an active warrant through Kelso PD right now. So we just want to make sure that all that is cleared up and we can go and have Sherry Farr do the investigation.
Wait, pause. I'm on drug court. I just met with Candace, my drug court counselor, Judge Hahn. I'm sure you're aware of it. Not one anything. What is the warrant for? I have no warrant.
I don't have any information today, Mr. Radcliffe. So we're not going to do this today. I'm going to extend the orders that have been put into place. Doesn't mean that they'll keep going, but I want you to get an attorney on board, and then we'll do what we need to do from there. Okay. It's not a done deal, but we just can't do it today. We can't just show up in court and start asking for things. It doesn't work that way. Okay.
Yeah.
Okay. All right. But as far as today, I think we've done everything we're going to do today. I'm glad you're here today, Mr. Radcliffe. That's really good. reach out. Sherry Farr is the person that you need to talk to. Ms. Winkles, can you provide Mr. Radcliffe her contact number?
Absolutely. And I'll also go ahead and send out the JIS because Mr. Half these things these people don't know about anyway, and they're from, 5 years ago. So I'll go ahead and provide him the Ms. Farr's information and also provide him the JIS statement so that he can take care of those things that might be just not swept up.
All right. All right. That takes care of things for today. Okay.
All right. Thank you, Your Honor.
All right.
That matters ready, Your Honor.
Okay, we have Ms. Winkles.
Yeah, Mr. Radcliffe.
Okay.
Good morning, Your Honor.
I have Mr. Gooday.
And Sherry Farr, the guardian ad litem. Although, Your Honor, I was appointed verbally, but I do not have a written order yet.
Okay.
Is there a way that I could ask for a
Hold on, Mr. Radcliffe.
apologize?
Okay. So, in regard to the guardian ad litem order, Ms. Winkles.
Yes, Your Honor. We'd also ask for Ms. Farr to be appointed. I'm sure the dad, Mr. Radcliffe, would also like that so we can move this along. What we're asking for today is pretty simple. Just no contact with the child. The child's not seen dad in since the child was an infant. Just no contact until the GAL has a chance to review. That's all we're asking for today.
Any agreements at this point for continuance?
Yes, Your Honor. In the minor guardianship of Serenity Aldrich, we have signed the orders. There does need to be an interlineation of for the GAL on the other section of the GAL order, but I believe everybody has agreed to that. We just need one line that I apparently missed.
Okay. All right. Anybody else wish to speak to that? So do we need any future review date or anything of that nature, Ms. Winkles?
I don't believe so. We'll docket that, but I just wanted on that GL order under other to say the GL has the authority to investigate the current visit or the visitation of mother and father so that she can update the court on both of them.
Okay.
And I don't see my clients here, but I'm assuming we'll have a court date once the investigation's proceeding and things of that nature.
I was going to docket it, but give a little bit of time for the GL to do the review.
Sure, thank you.
And you said that's which matter?
That's the Aldrich, Serenity Aldrich.
Okay. All right. With that, if there's no objection, I will go ahead and strike or call that done.
And did you want me to get you the new order with the language, or do you want it to just interlineate yourself?
I don't have any orders.
Okay. Well, that makes it easy. I will make sure my legal assistant runs one over this afternoon with that language in it.
All right. All right. That takes care of that matter.
Okay, let me go up here on the Aldrich matter, 2449-08, Ms. Winkles.
That matter's ready, Your Honor.
And I didn't, is Mr. Goodday here? Ah, there he's coming in. Let's make sure he's coming in here. All right, so this was a motion to compel. Where are we at on that?
We've received no response, which we didn't expect to. I believe that Mr. Gade is working with his client. I'm not sure about that. I'd asked to sign the first order compelling. Your Honor can make the decision whether or not fees are appropriate, given that Mr. Gade is appointed counsel for Mr. Radcliffe. But I'd ask that we have a review set in 2 weeks, and hopefully we'll have the discovery by then. But I would ask that the first order compelling be signed.
Excuse me, I'm Mr. Radcliffe. I've been trying to contact Good Day and everything, but I haven't been able to fill out the papers that were asked me to fill out. So I haven't seen them at all or anything. Like, I just talked to Far last night, and she told me to talk to the judge about maybe getting a new attorney or something, or maybe do something about this.
All right, well, hold on a second. So let me talk to your attorney for a second. Mr. Goodday, did you receive the motion on this one?
Yes, Your Honor, and I did receive a call from my client, and then I was understood that he was in treatment for a while, so we haven't been able to connect, but I would like some more time if I could to speak with him.
So I guess my question is a request to have discovery completed and returned by July 16th, which is 2 weeks from today. Is that sufficient time to have that accomplished?
Yes, Your Honor.
Yeah.
All right, let me see here just a second. I don't know.
And just so your honor's aware, that order proposed does have that attorney fees language in it that is standard, but I understand him being court appointed, your honor. I defer to the court on whether you scratch that or not.
And I don't have an action, there's an order filed. I don't have a bench order that I can see here. I'm looking.
And we can shoot it to you again. It was provided to the court about 3 weeks ago, so with the original motion, so it might just be flying around the court. I can have my legal assistant deliver another one.
Okay. I think at this time, given the circumstances of the Mr. Goodday being appointed counsel, I will decline on the fees at this point. That may be something I'll reconsider at a review. But at this time, I'll set a review in 2 weeks on the 16th from today. Assuming all of the discovery has been received, that can be stricken. If it's not received, I'll take up the request about attorney's fees at that time. So, Mr. Radcliffe, you and Mr. Goodday need to make sure you connect up in some fashion, get the documents signed and back to Ms. Winkles. We'll take a look at it in 2 weeks.
Thank you, Your Honor.
All right, thank you.
Thank you.
All right, you're welcome. 2 matters on the docket today. The Aldrich matter. Ms. Winkles, Ms. Goodday, this was on for discovery review, I believe.
That's correct, Your Honor. My apologies. I can't turn on the camera. I'm using a hotel Wi-Fi at the moment and it's spotty at best.
Okay. So we were here on the 2nd and you were
Yes.
waiting for some information, and I don't know that I have any further information from that.
Your Honor, we received some discovery the other day. About 30% of the 30% would probably be adequate or accurate. We've received no production responses. What I'd ask for today is a set over for a review, not a set over, a review in 2 weeks' time, and essentially moving down that list of a little harsher terms. So in this case, Your Honor, we've been here before. I would ask that he get us those things, and we can even say 3 weeks. And should he not do it, that he's unable to testify at the upcoming trial on the things he doesn't produce. That would be my request. And we can give him enough time to submit it, because what I want are the items. I don't necessarily want him to not to be able to testify. So giving him enough time would be fine.
A good day.
Yeah, that sounds fair, Your Honor.
All right, so if we were to put that on for the 6th of August at 10:30, with the understanding whatever issues were not turned over, he would not be able to offer testimony at trial.
Understood.
All right, that works, and I can prepare the order, and I'm sure Mr. Goodday and I can just sign off.
Very good. That can be submitted ex parte, and that could also come in electronically if that helps.
Okay, that works. Thank you, Your Honor.
Thank you.
All right. You're welcome. Guardianship of Serenity Aldrich, which is 2449-08. See Ms. Winkles is present. It's Mr. Goodday. Do not see Mr. Goodday.
And I've received nothing back in terms of interrogatories or discovery responses. And that might be why he's not here. I'm assuming he has tried to get those.
Let's call that again.
Okay.
Got a real short docket. He may be still logging in.
Okay.
Mr. Goodday, can you hear us?
Yes, Your Honor.
All right. So on the oops, I just got the wrong one of those things done. On the guardianship of Serenity Aldrich, this was on for discovery review today.
Yes, Your Honor, last time we submitted a response, and I think Ms. Winkle said if, we didn't respond more, then there may be issues with what my client would be allowed to testify to.
Yes, they essentially responded with not applicable or something to that nature to almost every question. So in that case, Your Honor, I would ask that their testimony be excluded on any question they didn't answer in full, which is probably about 90% of them.
Well, they would be limited to whatever discovery responses that they responded with. So that wouldn't be, I don't know what was answered, so I'm not going to just make a blanket exclusion of testimony.
And in that case, Your Honor, I can actually submit their responses and also the questions that we want excluded. If we set this over 2 weeks, I'd have time to do that. That might be easier. And it might also give them time to answer, because I still don't mind I'd rather have the information than have the testimony excluded.
All right, do you want to set it over the 20th for review? And then Mr. Goodday, if you want to provide additional answers, that we can consider that on the 20th?
Yes, Your Honor.
All right, so 10:30, 20th of August.
All right, thank you, Your Honor.
All right, then I want to call the minor guardianship of Serenity Aldrich, 2449-8.
And Your Honor, I'll be the only attorney appearing. We are very close to settling this, and so we wanted to set it over for 2 weeks. We don't need the discovery if we're going to settle, so that's why we're kind of putting a stop on that just in case that can happen. And so I'd ask for a 2-week continuance. Opposing counsel's on board with that, obviously, for his client. Ms. Farr is here today, and we're hoping to get Ms. Farr discharged if we do have to come back. In any event, we're very, very, very close. Maybe a couple more days and we'll know for sure.
So Tuesday, September 3rd?
That works.
And
we did try to set it over on over email, which is why I'm the only one appearing. But we were unable to do so. I think we waited a little bit too long to do it, which is why I'm here today.
I'm not exactly clear as to when this expires.
There is there's a guardianship, so it's a very strange case. There's a guardianship in place already. And my client's that's gone through to the end, but dad came in afterwards, got a DNA test, proved that he was dad. So we opened this back up to attach him. I believe it's till the pendency of litigation, it's till the trial, I believe is the order entered. If it's not, I can get an agreed order signed around, because nobody will have a problem with what's currently there. And so but there is a guardianship already in place. My client has letters of guardianship already over the child. It's just to add dad to that whole thing, because dad was excluded the first time because he had not had a paternity test.
Okay. So I'll set this to September 3rd at 10:30 then.
That works. Thank you, Your Honor.
I just have 2 matters on today. Ms. Winkles, are you here on the Aldrich matter?
In court. I am, Your Honor.
That's 24-4-00009-08. And I look like this was just on for review. Is Mr. Goodday's present? I see him there.
Your Honor.
So where are we at in this case?
Yeah, we're asking that, and we put in a declaration and put in the ROGs that we got.
what we're asking for is that dad be precluded from testifying or introducing evidence about the things that he didn't give us the evidence for. There's a list of them. It's not very long, just some kind of important items. So we'd ask that that he be essentially excluded from giving testimony. We believe we served back in April, so it's been months and months. Still waiting. Not sure. Don't think we'll ever get them at this point. And I'd like to set this for a trial so we can kind of move this case along and end it.
Mr. Goodday?
No objection to setting this for trial, and I'm not sure that I've seen the declaration of what my client would not be allowed to testify to. Maybe I missed it, but
when was that filed? Because I don't have anything filed since August 20th.
It was filed last week, I believe, on Thursday. I can shoot everybody a copy. It's just the interrogatories and then a quasi motion that just lists out a couple of things.
Yeah, I didn't even see that as being pending to be filed at this point.
Oh, that's interesting.
Also, was that
Hmm?
provided to us on Friday? We're caught up besides Friday's papers.
Yeah, so unless it came in Friday, my clerk's indicating that we don't have that.
Okay, it might have come in Friday very early in the morning in that case.
Why don't we do this, just because I think it's appropriate for Mr. Goodday to at least have notice of what that is. I'd like to see it. Why don't we set this over 1 week?
Okay.
I'll review it at that point. So that would be the 10th at 10 o'clock.
Okay, and then if
30.
Your Honor wants to make a decision, I'm not sure if Mr. Goodday wants to come back or not. I don't mind either way what Your Honor chooses. If you wanted to just make an email decision as well, that's fine with me. I don't need to do argument.
What my thought would be is generally on those things is he would be limited to testifying to whatever information he's provided.
Yeah.
And I don't know what all that is at this point, so.
Okay, and I did actually submit the interrogatories and request for production answers as well.
All right. So if you want to go ahead and file that, if we don't need to come back next week, we don't need to. I can just simply put it on for trial assignment next Wednesday if you want to do that.
That would be great.
That's fine with me, Your Honor.
All right, and then I can give you a ruling. I don't know what's in the declaration, but I would limit his testimony to what answers he's given.
And that's pretty much what my declaration states, is that here are the interrogatories.
Okay, so let's not put it on the 10th. We'll put it on the 11th at 9 o'clock for trial assignment. And then do we have any kind of a order ending anytime soon that we need to worry about?
I don't believe so, because this is actually kind of a strange one in that the mom was already under a guardian. Essentially the child's already been under a guardianship through mom, and then dad did a DNA test and came on later. So that there should be an actual full minor guardianship already with the child. This is just to essentially add dad under that order.
Do we show that? Because I just show this as an emergency.
I believe it's a different case than this. It's not in this.
It is a different
Oh.
case number. It is a different case number.
Oh, I see. Okay, there we go. That's weird. It's consolidated into this one and not into that one.
Yeah, and there's actually 2 other cases that were before my time that were for a different third-party guardian that were also consolidated only into one case. So there's actually, I think, 5 cases in total. 3 of them were open before my time, and then I did this one. And there's another one floating out there as well.
Well, I show the last activity in that case back in 2023 in August.
In the original one, that sounds about right. There was
Well, in the 133 case, but that's the one that we should be doing all of this in. So.
Yeah, I believe it was the wrong one was consolidated, and we just kind of kept going through that one. I can do a motion to consolidate all of them if that makes it procedurally easier for the court.
Well, I think we should, you may want to check with the clerk's office and see what that takes, because I mean, we can't do a final order in the emergency case. We have to do it in this case.
Yeah.
And I don't know if he's been served anything in this in this case.
He has the service, the notice in both cases is they're all of the documents. So he was served with the original emergency and the full minor in both cases. So this was, I believe, I may be wrong, but I believe this was at the time right before they changed the statute to allow you to file an emergency under the minor. So this was right at that time where you were filing a minor and an emergency, if I remember correctly. And that's where it kind of got a little screwed up. So the service, he'll have been served everything. And I believe the certificate of service actually states all of the things he was served at one go. Because I believe he might have been served in jail, actually. Does that sound right, Mr. Gooday? To you?
I think so, and I feel like he might have even filed this or.
He filed for one part of it. Yeah, he filed his own petition as well. But that might be the fourth one the fourth case. There's so many.
We probably need to check on that because procedurally we wouldn't be setting this case for trial, we'd be setting the permanent one for trial. And I don't show this case, the one that's on today, as having been filed until after the last thing that was done in the first case. By about 6 months. So there's nothing filed in the other case about service in that case.
Okay, in that case, let me, if we can give, if you can put this on the trial setting 2 weeks from now, what I can do is I can file everything from this case into that case as well. And make sure that they're both, because the documents are the same. So it'll be the full minor. It'll just have a different case number on it. But he was,
I just want to make sure we have the right case in front of the court for assignment on let's put on the 18th then at 9 o'clock for assignment. And then take a look at those cases and just, because I want to make sure we get the right one teed up for trial.
Okay, and if I need to strike that, I'll strike and I'll do docket notice for the other one if I have to.
Okay, so we'll strike everything. Let's put both matters, both those cases.
Oh, that'll work.
On for the 18th at 9 o'clock, and then hopefully we'll be able to get that resolved and move forward. I do. It is 23-4-00133-08.
And I will contact Stacy at the clerk's office and see if she can help me out to figure out what to do with all these case numbers.
Perfect. All right. We'll see you in a couple of weeks then. Thank you.
Okay, thanks.
Thank you.
Thank you. Then I have the Kelly and the Foxes.
They had their trial assignment hearing on September 18th and their readiness hearing on November 12th, where they set the trial for November 21st. On November 21st, the trial was stricken and instead, the judge signed agreed orders, so the parties must have come to some sort of mutual agreement on visitation. That was the last time that they were in court, and as of July 2025, both of the children seem to be settled into permanent homes. Dad has full custody of his son, and Mom has supervised visitation that is currently suspended, while the maternal grandparents have a full minor guardianship for the daughter, and both Mom and Dad have supervised visits. I hope both of them are able to stay clean for their children's sake. Thanks so much for watching.